Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. First case on the calendar for oral argument today is People v. Towns. It's case number 298.
Good morning, Your Honors. Jane Yoon for Mr. Towns. Unless the court has any questions, I would rely on it.
Thank you, Counselor.
Bridget Field on behalf of the people. I as well will rest on my brief unless the court has any questions.
Thank you so much. Case number 299, People v. Wright.
Good morning. My name is Aaron Friedman, and I appear today on behalf of Clifton Wright. I'll be addressing all 3 points in the order in which they appear in the brief. First, the court-imposed waiver is not enforceable by the people because they weren't a party to the agreement that led to the creation of the waiver. The idea that a non-party to an agreement can't enforce one of the terms of that agreement is a foundational legal principle and one for which the only notable exception is third-party beneficiaries.
Counselor, do you have any case in the state of New York that so holds in this context?
In this context, no.
So you want us to have a decision of first impression going your way on this one? Nothing wrong with that.
That's correct. Now, courts have heard the Sutton argument. Most recently, this court in the People v. Turner case, Justice Del Conte, Justice Nowak, you were on that panel. This is a distinct argument. That argument is that for the waiver to be valid, the court needs to place the reasons for requiring the waiver to assuage any fears that the court's motivated by a concern to insulate itself from appellate review.
We haven't gone to Sutton in that regard.
Not yet. This is a distinct argument. The two main differences, I would say, this is routed in more of a contract principle than the principle in Sutton and potentially Turner is that the appearance of due process alone could implicate, the appearance of impropriety could implicate due process.
Do I have it right that this, if we went your way, it would essentially invalidate any waiver of appeal that was brought up by the court on a plea to the indictment?
That's correct, Justice Curran. And the benefit of that is that it wouldn't invite future litigation in terms of when the court's reasons would be sufficient to make the waiver valid. So it's based
better than Sutton.
Correct. It's a different. We would be very happy for the court to rule in our favor on Sutton grounds, but this is a different justification. Again, I think it's simpler and easier in its administration.
And you know that we have other cases where we have approved waivers which were instituted by the court.
That's correct.
On a plea to indictment.
That's correct. So
you want the full boat. That is, you don't want to just have as first impression. We're going to have to abrogate those cases under your argument. Do I have that correct? And don't agree with me just because I'm asking the question, but like I think there's a case that's at the Court of Appeals, the G is in the Figueroa, and then there's Ware, W-E-I-R, that I think was just decided not too long ago. I know I was on it. So my question is, we'd have to do double, not only case of first impression, but also abrogate our current case law, right?
I don't believe those previous cases would need to be abrogated because I don't believe this particular justification was in front of the court. I believe the questions in those cases were just whether the 4th Department would follow Sutton, and in those cases, it declined to do so. So because this argument wasn't in front of the court and that wasn't the ground on which—
It's lose and your defendant wins.
Correct. Moving on to the second point, even if this court would find the waiver couldn't be enforced by the people, it should nevertheless find that the waiver was not valid because the record doesn't show it was knowingly, intelligently, and voluntarily entered into. In addition to the other points which I discussed in my brief, it's not clear that Mr. Wright understood that he was getting the sentence promise in exchange for the waiver rather than the opportunity to plead. His attorney said that the court would accept his plea with the waiver of appeal, but what he wasn't told is that the court had to accept his plea. He pled to the indictment, which he had a right to do, and he was never informed that he had this right. The court never used the formulation that the waiver was for the sentence. It used alternate formulations like plea deal, plea and sentence. And there is no plea deal here in the normal sense because there is no agreement in terms of the charge or the count that he's pleading to.
What was the minimum sentence he could have gotten? Remind me.
So he got the minimum sentence in this case. It was, I believe, 3.5 with 2.5 years, and he just got out in February.
So by electing to plead guilty to the indictment, he couldn't have done any better.
That's correct. He did the best that he could do, but if the colloquy made clear what the waiver was,
He could have gotten a lot worse. I'm sorry to interrupt you yet again.
that's correct. That's correct. So it's not merely a question of whether he received consideration, it's whether that's what he understood at the time.
You're saying that it's unclear whether he thought that the sentence was encompassed by the plea, by the waiver?
Not whether the sentence was encompassed by the waiver, but what he was getting in exchange for the waiver, whether he was just getting the opportunity to plead guilty. He had the right to plead to the indictment, which is what he did, but he never did. He never was told that. So I don't believe that it's clear if you look at the colloquy, whether he knew he could plea at all. I mean, the court could have said, you can plead guilty and I have to accept your plea, but I don't have to give you the minimum sentence unless you waive your appeal. That would have made the colloquy clear and
stray from the model colloquy, the model waiver colloquy.
in certain ways it did. It, I believe, told him he had the right to an attorney, but not the right for the state to pay the cost of the appeal. It included statutory
issue with respect to that you're challenging. Did the court, it seems like the court did read right from the model colloquy.
That's correct, but the model colloquy frames this in terms of whether or not the appeal right survives the trial right. The issue here is that he had to, even to get to exercising his right to plead to the indictment and waive his trial right, he could not even do that unless he first extinguished his appeal right. So it's not a question of, in the normal context, it's can I appeal after I pled guilty? It's here, can I plead guilty without waiving that right?
Why don't we move on to your substantive issue, point 3 on the seizure.
Thank you. So we agree with the court that the police initially had a level 2 founded suspicion to approach Mr. Wright. And we agree that this escalated to a level 3 reasonable suspicion when Mr. Wright fled up the driveway. So the only area where we disagree with the court is that we believe that the police effectuated the level 3 seizure prior to them having the proper basis to do so. So I would urge.
And does that come down, Counselor, to when the gun was displayed?
Correct. So
Okay.
If it's just 5 seconds of body worn camera from 4:30:35 to 4:30:30, and at 4:30:37, you can see that Lieutenant Adams is pursuing Mr. Wright at gunpoint. He's ordering to stop. But at 4:30:38, Mr. Wright is still walking down the sidewalk. He hasn't yet begun to flee up the driveway. So there's
At what point did the officer see the gun in his hand?
So the testimony was that the officer saw the gun after he began his pursuit. So the level 3 seizure had already begun.
But he saw something in the hand that was black before that.
That's correct. But absent any additional description or information that would lead him to believe that it was a gun, and nevertheless, the court found that he didn't have didn't have the level 3 reasonable suspicion until the flight. It was the flight that escalated it.
So you would posit that there was level 2 suspicion here to inquire.
Correct.
They heard gunshots in the area. The shot spotter placed it right in that location. Police arrive a minute later. They see several individuals. They try to inquire, but your client walks away, starts leaving. They see an object in his hand that could be a gun. They just heard shots moments later. The officer says, stop. At that point, you say that's a level 3 and you need reasonable suspicion once he says the word stop? Or is it the pursuit?
So I would add just one distinction, which is that the police only heard one gunshot, which I believe is relevant because there's multiple people.
Right.
It's kind of close in terms of what happened, but ordering him to stop would not be enough without the gun drawn as well. That's my understanding, at least. So it's the pursuit with the gun drawn and the verbal commands are kind of all at the same time.
So at that point, they should have just let your client walk away. Right? They had no business doing anything other than saying, hey, can we talk to you? No, okay. Have a good night.
I believe they only had the level 2 founded suspicion, but importantly, that's what the court held as well.
Counselor, your argument that you make in the reply brief regarding comparing the 2 videos and the timing. why are we assuming that the timing is identical to the second on the two body worn camera videos?
So the police authenticated the videos. They said that they were accurate, and the burden is on the people to establish the lawfulness.
Right, but in order for the argument to work, it's got to be identical to the second. It can't be a situation where the justice presiding's wristwatch is, 4 seconds ahead of my wristwatch, and then we're comparing the two. It can't be that. It's got to be right, perfect.
I think that's correct. I think that
For your argument.
that's correct.
Okay, if we can't assume that because it's not established either way, we do have Officer Adams' body cam video, and doesn't it appear to you that when he gets to the scene and begins to open the door of his vehicle, before he even gets out, he's yelling, "Stop"?
He's yelling stop. It's unclear whether he has his gun out or not, but you can't see Mr. Wright in Lieutenant Adams' video. It's only in Officer Lindauer's video.
I appreciate that, but even if the gun is out, he's behind his door of his he's not out of the vehicle yet. He's still getting out of the vehicle, right? When he's yelling stop.
It's in my viewing of the video, it's sort of all at once. There isn't a clear delineation between now he's standing, now he's running. It's more of, when you watch it, it's almost as if it's one motion, getting out of the car, yelling, running, taking his gun out.
Fair enough. You'd agree with me. At no point does he get out of the car, stop, and point a gun.
That's correct.
That doesn't happen.
That's correct. Yeah.
It's a quick,
It's sort of one,
get out and go.
one set of actions that all occur at the same time.
Counselor, this is the way I saw the BWC, that Lindauer, I think, was the first one at the scene by maybe a second or two, right?
I believe that's correct. Yeah.
And he's focusing, among other things, on the unidentified individual who's kind of standing closer to them at what looks like the corner.
I
Right?
think, yep, on the left side, and then Mr. Wright's on the right side.
In my eye, I see that either Lindauer's flashlight or spotlight on his vehicle, I don't know which, is focused on your client who's about a driveway or a driveway and a half down the street, correct?
That's correct.
So when Adams arrives, your client has that light on him as I see it. And then Adams testifies at the hearing, I saw a small black object in his right hand, and he kind of moved his hand in a manner away from me. So that's what he sees before anything else happens, right? And then your client doesn't stop and he takes out his weapon. So guess what I'm asking you, do you agree with my view of the BWC, first of all? And second, for you to prevail, do we have to say that the BWC contradicts Adams's testimony and relies solely on the BWC for you to prevail?
So there's a LaFontaine issue here because of the way that what the court found. The court found the level 2 to the level 3. I think that some of the testimony was equivocal in terms of when he did what he did, when he saw what he saw. There is some testimony to the effect of it was fairly fast, all at once, not instantaneous. So I'm not sure how clear it is just from the testimony alone. I don't know if it's clear enough that the court would need to find the video actually contradicts it. I think it's a closer call than that.
If the officer saw a small black object in your client's hands before pursuit, that would justify pursuit, would it not? Given the other facts.
I'm not sure just a small black object alone. I mean, that could be a cell phone, that could be any number of things, absent any additional description about the shape. Small cuts both ways, depending on, absent additional description. So is that enough information just that we know it's small? I don't believe so. But again, given the court's holdings, that there's a LaFontaine issue here as well.
Thank you very much, Counsel.
Thanks very much.
Field, good morning.
May it please the court, Bridget Field on behalf of the people. I believe that the people have standing to argue this waiver in this case. The people have an interest in the outcome or the finality of convictions. This isn't a contract case, it's a criminal case. We believe that the people have standing to argue the validity of the waiver.
But you didn't negotiate for it.
It does not appear so on this record.
Right.
I mean, if there was any on this record, I cannot say.
Does the court below have an interest in finality?
I would agree. I would argue yes. But in here, this was the defendant was offered the minimums. I mean, so he was offered something. He wasn't, he did receive something in exchange for the waiver of the appeal. He could not get a higher sentence. So, he received something for agreeing to waive his appeal.
Right, he got the minimum sentence. What he gave up was arguably the ability to argue on appeal the suppression issue that counsel was just talking about.
Correct. And I don't think that there's any evidence in this case or on this record that there was any such motivation behind if I recall, Judge Dollinger's decision to include the appeal waiver. Whether what happened, if there was any type of conference beforehand, I don't know. But on this record,
these are discussed behind closed doors.
correct. On this record, it is silent as to the people's input as to an appeal waiver in this case.
I mean, and you look at the full BWC, including the chase into the backyard of the one house 2 doors down, and you listen to that and see what's happening. These officers are extremely concerned because they now know that he's got a weapon. They don't know where the weapon is on the ground. There's some reference to you having to use a taser on the defendant, and the court knows all that, but still lets them get the minimum.
Correct.
And then you're burdened with having to defend it on appeal.
Correct. Yeah, the body worn camera, Officer Adams did testify at the suppression hearing. Officer Lindauer did not, but both videos were put into evidence. They show a chaotic scene, and you see the video actually started while the officers were at an unrelated traffic stop. You can see, should anybody care to, the entire traffic stop at the other scene, and they drop everything because they hear a shot, and then there's an announcement over the radio because of the shot spotter. I never can say that word right. I apologize. Because of the shot spotter, and they get over to the scene where the shot spotter had been activated within, I believe it was within a minute. It was very, very quickly. So they're aware that there's been not only a gun seen there, but there's a gunshot.
Right, you cite some cases from this court that I believe stand for the proposition. Now, maybe we were wrong, but in that situation on a level 2, the police can order somebody to stop for safety reasons. Like, show us your hands, and then we'll inquire. Is that what you're arguing here? Even if there wasn't level 3 at the outset, there's a safety exception to level 2?
Absolutely. Under the facts of this case, absolutely. Although I still believe that we meet the level 3 situation. The body worn camera, it doesn't show. Officer Adams testified that he had seen the defendant turn and something, a small black object in his hands or hand. That isn't shown on the video. We see the video, Officer Adams' video, it's chaotic. He's getting out of the car. He's immediately asking or yelling for the defendant to stop. There's quite a number of times that I don't recall if it was one or both, are saying stop, stop, stop.
They're yelling hands most of the time. Like, show us their hands. But
yes. They're certainly, they didn't, as one justice said, they didn't get out of the car, stop, leisurely, look around, see what was going on, and then start yelling commands. This was immediately as he was getting out of the car. An officer, the defendant is seen more in Officer Lindauer's video than in Officer Adams, because Adams is kind of getting out of the car and running after him.
Right. Anything further?
Not unless the court has any other questions.
Thank you.
Thank you.
Next case is number 300, People versus Kevin Small. Good morning.
Morning, Your Honors. Stephanie Stair for Mr. Small. I will skip straight to point 2 unless this court has any questions about the waiver of appeal. The factual colloquy here was insufficient to sustain the plea to burglary in the first degree. First and foremost, in terms of preservation, this falls solidly within the Lopez exception when the factual recitation negates an essential element of the crime pleaded to. The people contend that the court cured the insufficiencies by explaining that what happened was still a crime. However, all the court cured was basically a criminal trespass in the second colloquy, and Lopez requires that the court inquire to ascertain the defendant's knowing, voluntary, and intelligent plea to the charge to which they are pleading to, which was burglary in the first degree. Page 8 of my brief shows essentially the entire colloquy, wherein Mr. Small repeatedly says he did not intend to commit any crimes when he entered the home. The court did point out you can't go into someone's house and retrieve your own property. That's still committing a crime. And again, that's only trespass followed by an assault, not burglary in the first degree.
Your position is that there was a misapprehension by the prosecutor in the court that taking back your property from somebody is larceny. Because that's what your client seemed to suggest. What he was taking was the headphones that the victim had taken from him wrongfully. And
Right.
under the law, People versus Green, that's not larceny. If you take from somebody which belongs to you. Here it was a crime. You can't go into somebody's house to do it
Right.
because that's criminal trespass. But for burglary, we need the intent
Correct.
prior thereto. That was the mistake here that needed to be clarified in your view. I was curious this was a squatter's house, apparently, according to the plea transcript. The victim was a squatter, the complainant.
I would defer to the court.
Well, throughout the plea colloquy, the indictment alleges the burglar was going into the house. Then he gets to the plea, the burglar was going into his room, and it was a squatter's house.
Right.
I mean, nothing here made any sense.
Correct.
They cried out to me for a few follow-ups, but your argument's really on this. He negated the intent element on burglary.
Correct.
Required further inquiry. There was none, so the plea should be vacated.
Correct. And I would point out that one of the co-defendants did only plead to that CT2 criminal trespass second, and the third co-defendant had their charges dismissed entirely. Mr. Small was the only one who was required to plead to the burg first. He got a sentence of 10 years. And oddly enough, the original offer was attempted burg second with 5+5 condition on all three taking it. And then in the end, we have one misdemeanor plea, one dismissed charge, and then Mr. Small with this very insufficient colloquy serving 10 years.
I mean, there might have been, your client went in there and assaulted the person who stole money too.
Correct. And he took full responsibility for that.
It could well have been a burglary, just not based on the intent to take back the headphones.
It could have been, but that's not how the colloquy went down.
Right, yeah.
They were pretty stuck on it being the intent to steal up at the point of entry. I don't need to go too far into point 3. I would just say Mr. Small's his seemingly seriously request he had factual information regarding a defense. I would contend that's as serious as it gets. And saying your attorney is really good does not equal a sufficient inquiry by the court in terms of Mr. Small's request for new counsel.
All right.
The court has no other questions. I would rest on my brief.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. I'll focus on point 2 as well. It's the people's contention that the Lopez exception doesn't apply here because what the Lopez exception does is guarantees a defendant an opportunity to make their plea sufficient and make sure that they know what they're pleading to. Here, the people's position is that the court gave defendant that opportunity when it essentially paused the colloquy and asked follow-up questions. And I would want to contrast this with an example that I don't think would be a sufficient further inquiry. That's one where the defendant negates a element and the court rather says, do you want to plead guilty anyways? Here, that's not what happened. Here, the court goes into factual questions, tries to explain to the defendant that what he did ultimately was still unlawful.
You agree, I believe, in your brief that the defendant did make a statement during the colloquy that negated an element.
Yeah.
You agree
And
with
that,
that?
I do
So
agree
now
with
we're
that.
talking about the court's response under Lopez.
Yeah.
What inquiry do you make? The way that Mr. looks at it is that the response was to say, you can't go into a house and take back your cell phones.
Right.
That's still burglary, which is, well, it's still a crime, he says. Technically correct,
Technically correct,
but
but not
necessarily
entirely correct.
burglary, not necessarily burglary.
My response would be that the court is trying to make sure that the defendant isn't insisting, that doesn't understand that he's pleading guilty to something. And here, the defendant really committed 3 different versions of a crime when he entered this domicile. He assaulted the victim. I think there were actually 2 victims. I think that's where the confusion came upon with 2 different charges of burglary. Then he stole money, which actually is not a defense. You can't say, oh, this person owed me money, therefore I assaulted
The
them.
intent to assault and steal money had to be formed before entry.
Right.
And that's where arguably, look, it's easy in hindsight for us. We can put our feet up and read the trial. I know the trial judge here had a lot of cases and it's harder to do it live in real time, but in hindsight, it should have been, look, you're saying you went in there to get your headphones back. They belong to you. He could have broken up. If you went in there, did you go in there with the intention to steal money that didn't belong to you? Then burglary.
Right, Judge. And I think the difference here is it seems, I know from the defendant's perspective, it's not like this. I'm not trying to make light of it, but it seems extremely, extremely like it's a technical, very technical argument here that the colloquy really needed to establish what crime formed the intent when he broke into the house. I was trying to establish that there were 3 distinct sort of things he did inside the house that were essentially crimes. But
They weren't part of the colloquy.
They weren't part of the colloquy. And so the court wanted to make sure that, hey, look, the court put the pause button on, hit the brakes. And I want to emphasize that this wasn't just a 1-question follow-up. There's over a page of transcript here where the court is trying to have this conversation with the defendant to make sure that the defendant knows that he's actually is going to be pleading guilty to this. And you can forego a viable defense when you plead guilty. That's something that you can do. And what the court needs to do for the Lopez exception to not apply is essentially hit the pause button. Because when the Lopez exception comes in, we're worried about a situation where the defendant doesn't have an opportunity to challenge the plea and the court accepts it without further inquiry. And that same sort of rationale gets kind of put in with other cases that are similar to Lopez, like when things are stated at sentencing and when things are stated when the judge is proclaiming sentence. When the judge is proclaiming a sentence, the judge can't inform the defendant of an aspect of the sentence that was never part of the plea.
I think really what it comes down to is, did this defendant know when he pleaded guilty that going into this squatter's house or room, whichever one, and taking back his headphones was not burglary if he intended just to go in to get his headphones back? Because that's not burglary, you would agree. Did the defendant know that? Now, if he was told that, he says, okay, I'm going to plead anyways. Totally fine.
Right, Judge. And I think that in order to get to that argument, in order to dissect that technical argument, this needs to be preserved. And I don't think that's what the Lopez exception is here for. The Lopez exception is to give defendants an opportunity now via appeal, but give them an opportunity to go back and examine the plea colloquy itself. That opportunity was given to the defendant here by the further questions. Was that opportunity perfect? That's a question that needs to be preserved before this court can reach it. And that's not what the Lopez exception is for. And I think that if there had to be a motion to withdraw the plea, or there had to be some sort of challenge by defense counsel who remained silent at the time of the colloquy in order to preserve that for this court's examination.
Thank you so much.
Thank you.
Case number 301, People versus Michelle, Liz, MV. Michelle is MV 301. I apologize if I mispronounce your client's name. How do you say her name?
Michelle.
Thank you.
Good morning, may it please the court, Sabrina Bremer on behalf of Michelle V. To begin, the waiver here does not preclude review of the county court's removal decision because the waiver was executed on the condition that the removal decision would survive the waiver. And then turning next to the removal decision, under the plain language of the statute, the people fails to show that she displayed the gun in furtherance of the offense of criminal possession of a weapon. The term in furtherance of must be given effect. It can't simply just be that she displayed a weapon. And although
Sounds like you're conceding display or not arguing it.
I'm not arguing display, I'm focused on in furtherance of. And although in furtherance of is not defined in the statute, looking at dictionary definitions, it requires promoting and advancement. If display alone was sufficient, the legislature could have done so, as it does in burglary in the first degree or robbery in the first degree, where display alone is enough to get you to that crime.
Counselor, here's where I'm stuck on the language. So
Yeah.
following up on the justice presiding question, you seem to say, okay, there's a display, so you're willing to go that far. Then in furtherance of is the focus of your argument, correct?
Yes.
I'm focused on the next two words, in furtherance of such offense.
Mhm.
Do you agree that such offense in this circumstance refers to the CPW charge?
I think so, because that was the only charge. And there was an argument below that display and furtherance of the crime of criminal possession of a weapon in the second degree is sort of a circular issue. But I don't think that this court needs to even reach the issue of in any circumstance, is it, can you display a weapon in furtherance
Here's where
of?
I'm going with that question, is I read the statute, I think the way you read it too, that is such offense is the CPW charge, as opposed to what might be someone would think, maybe what they meant, the legislature was some other offense.
Mhm.
You know, displaying weapon, it's part of a robbery, things like that, but it says such offense. We're stuck with the language of the statute, such as it is. So if we read it as CPW, it seems to me then your argument ultimately has to be, and I want to make sure that we're on the same page. And if I'm not, then let's talk it through. That no CPW, every CPW charge must go to family court under your theory.
No, that is not my theory. So I think that the element of in furtherance of, to give it meaning, there has to be something more than just display alone. And so looking at other cases where the court found that the display was in furtherance of such offense, it happens in the context of there is a dispute and the display is used to make sure that no one else can have possession of the gun, or the gun is used to menace or threaten someone else.
That's why I asked.
I know.
See where I'm at? So if we
Yes.
focus on such offense being not some other offense, such as menacing or robbery or something, other crime, if it's such offense and it's CPW, then I still back to, I think the consequence of your argument is, as I said before, I think that every CPW must go to family court. And there I don't see the statute saying that exactly, but so you disagree with that, but then you see the conundrum you get into by having to refer to some other offense.
Yes.
Are we, and if we're not on the same page, please tell me why not.
No, I do think that we are in the same page where we are in a situation where it does seem that the intent of such offense could be read as it has to be some other offense. And looking at how the courts are applying it, there usually does seem to be an additional crime that could have been charged that might not have been, such as a menacing or a robbery.
Isn't that how it's usually used? My understanding of the statute says adolescent offenders charged with violent felonies, as defined in the penal law, are presumptively removed from criminal court to family court unless the defendant displays a gun in furtherance of such offense. I agree with the discussion that such offense could relate back to the CPW, but could it not also, and in most cases, refer to another violent offense? You rob somebody. You could rob somebody with a gun or without a gun.
Yes.
You could commit burglary like the last case, with or without a gun. If you display a gun, then it's in furtherance of such other offense. It seemed like that was what the legislature was talking about. But the way it's written, it does revert back to CPW. And if that's the case, mere possession of a gun, anytime somebody sees it or arguably it's displayed, that is removable. There's a lot of cases that would say mere possession is not removable. So those cases would be wrong. It's not it could be better written. We have a lot of cases today where there's contracts, there's deeds. I mean, a lot of things could be better written in hindsight. This was a little confusing.
Yes, I agree that the statute could have been written more clearly, but still even looking at that plain language of giving every word meaning in furtherance of, I think that under the facts of this case, all there is display. And then in addition, looking at the legislative history where an overwhelming bulk of these cases with adolescent offenders should be transferred to family court, the case law shows that unfortunately criminal possession of a weapon is something that adolescent offenders are often charged with, and the legislature intended for those.
Real quick, but on this such offense language that I do think refers to CPW based on the language of the statute. So 2 points. So I think that your argument leads to the conclusion, the necessary conclusion that every CPW must go to family court. If we don't read it that way, then an argument could be that no CPW goes to family court. Could be the other side of the coin, except when you have a situation like the people point out in their brief, where you have constructive possession. We have cases where the weapon is not displayed. So if a 16-year-old is sitting in the passenger seat of a vehicle and a weapon is found upon an inventory search under the driver's seat, there's been no display, that case could go to family court, correct?
Yes, that case could go to.
There's no display. So it's not the saying true. Yours is every case must go. The opposite is not true. You agree with that?
Yes, and also it wouldn't necessarily always go to family court because there still is the extraordinary circumstances exception where the people can show that maybe this display met the bar of this is extraordinary.
One further follow-up, and I know Justice Noe has a question too, but the other concern I've got about the such offense, if we say that every one of these CPWs must go to family court as a consequence of your argument, why then does the legislature refer to 3 or 4 different types of weapons in this section? If they're all going to go, why bother defining a firearm, a shotgun? Why bother having that? So I'm just kind of repeating what the Justice Presiding said. We're struggling with how to apply this statute. So you see that point, that is otherwise you're kind of just negating the reference to weapons.
Yes, but I think looking at the legislative history, it shows that when the legislature was thinking about this language, they didn't intend it to be weapon display alone. It was weapon display plus something else, similar to in People v. Cahill, where the Court of Appeals looked at whether the murder was in furtherance of the burglary or the burglary was in furtherance of the murder. And they found because that the defendant entered the home with the intent to commit the murder, the murder was not in furtherance of the burglary.
The definitions that you provide in your brief, you talk about promoting and all of that, the dictionary definitions that you turn to, and I appreciate you've already done an analysis of the legislative history too, which is very helpful. The one thing that you didn't cite was a case from the Court of Appeals, People versus Henderson. Are you familiar? Do you know where I'm going with this at all?
I'm afraid I'm.
No, it's okay. In Henderson, the court was dealing with the felony murder statute, which provides that if in the furtherance of a felony, same word, in the furtherance of a felony, you cause the death of another, then you violate penal law 125.25. The court struggled with in furtherance of there too, did the same thing and analyzed the legislative history. And they ended up with a definition that it requires a logical nexus. So not that it promotes or not that you had the intent going in, but that there just be a logical nexus between the felony and then the death of the individual. If we were to apply that definition here, we were to say, well, yeah, logical nexus. Is there a logical nexus factually in this case?
I don't think that there is, because she showed the gun to her boyfriend. It wasn't in the context of a dispute. There's very little said about the context other than she's sort of told him, I have a gun on me, and he's obviously upset, and they get into an argument, and then he later returns and tells the police.
She had already committed the offense well before she displayed it, right?
He committed, yes, the
Soon as she
possession.
stepped outside or arguably possessed the defaced gun, crime's done. Like,
Mhm.
can you act in furtherance of a crime that's already completed?
I guess I would argue no.
Yeah, I thought you might.
I would also argue the logical nexus language from Henderson. By the way, Henderson was cited in the defense counsel's motion papers below.
Mhm.
I also found it, like Justice Nowak did, with the in furtherance of language. But I would say that anytime you have a weapon, you possess a weapon, there's a logical nexus to displaying it, which gets back to the argument that, well, that means, Judge, that every CPW can't go. None can go. This is probably the better way to say it. But again, I think that constructive possession and accessorial possession probably are an exception to that argument, which is why maybe that argument is the better one as opposed to the broader one you've got.
Right. But then I think we have the legislative history, which again, overwhelming bulk of these cases should be transferred to family court. And if the facts of this case are enough to stay in criminal court, that is entirely contradictory with what the
You might
legislature.
get YO and probation. It's not going to make a tremendous difference for her, but we got to get this legal issue right going forward.
Yes, we have to get the legal issue going right. And she was sentenced to 6 months in Monroe County Jail. Ultimately.
After she violated and committed a new crime. All right, thank you very much.
Questions?
Morning again, Bridget Field on behalf of the people. I would agree with part of Justice Curran's argument. I mean, I've cited the situation where under accessorial liability or constructive possession, those are cases where a weapons charge would go to family court. This is the circumstance where the weapons charge could realistically be found to stay in youth part. The legislative language certainly, legislative history certainly talks about, many cases going to youth part, but I've cited two portions of the legislative history that also talk about that the intent is not for violent crimes, particularly those involving guns, to necessarily go to family court. So I believe that my interpretation is certainly consistent with the legislative history and consistent with the language.
So under your interpretation, we don't need the defendant to show her boyfriend the gun in the parking lot an hour or so before she was ultimately arrested. Just the fact when the police come to the gas station and they say, put up your hands, because she wore a shirt such that when she put up her hands, the shirt came up enough that the officers could see the gun in her waistband. That's the display. So then, that's the end of it.
There's always going to be a display. I think maybe his point is when you're arrested, because if the police don't see it, you're not arrested.
But that's not the case here. Here, she showed it to her boyfriend. She I think opened her shirt.
It has to be an intentional display, not an inadvertent.
Intentional display showing her boyfriend that she had the gun. The gun was, I believe, in her waistband, showing that she had control over this. If this was in the backseat of a car and she said, hey, I left the car in, the gun's over there, she wouldn't be showing, showing
scenarios.
furtherance.
How about the same? Let me give you these analogies. Because again, we're worried about the next case.
Of course.
Defendant walking down the street has a gun in the back of the small of the back in the pants. I think that's what our defendant here had, right? But it's covered, it's concealed. That is not, there's no display there. So that's family court if she gets arrested.
I would agree.
Family, it's removable.
Correct.
If that same defendant's walking down the street with some friends and one of the friends says, hey, what's that you got there? And you press it up, it's a gun, shows it to him a second, and they keep walking. That defendant, that case is not removable. Same.
Correct.
The only difference is the mere brief display. without any threats or anything like that.
There's no requirement in the
Right.
statute of there being a threat when the gun is
Right. So once you
displayed.
show it,
So once
You-
it's displayed,
it dictates where you go.
yes, I agree with that.
And that's not your rule. You're saying that's the legislative rule.
That is a legislative rule, and the legislative rule doesn't say that the in furtherance, has to be, that it doesn't, there's no requirement that it be pointed at somebody. The fact is, again, she could have just said, I have a gun. She didn't. She showed the gun. She displayed it and showed that she had control over that gun. And again, this is at an early stage of the proceedings. It's a preponderance of the evidence standard too for the court in finding the display, the display was in furtherance of the crime of, I believe in this case, the correct reading of the language would be in furtherance of the crime of criminal possession of a weapon. I think that the legislature could have excluded CPW charges if they wanted to, and they didn't. They included it as a violent felony offense.
Are they included or are they just presumptively? Is it a presumption? Isn't it just a presumption that all CPW 2 cases remain in youth front? Isn't it just a presumption?
I don't believe so, because there's a requirement that the weapon be displayed in furtherance of the crime. And as I argue,
In furtherance of the crime.
of such offense, and I would argue that of such offense is the criminal possession of a weapon charge. And I've cited to instances where it would be removable. So you're not displaying the gun if it's under the automobile exception, if it's under any constructive possession theory, any accessory liability theory. Those, I believe, would, yes, be removable to family court. So my interpretation of the statute isn't every single case, every CPW case ends up staying in youth part. There are definite situations where some of those cases would go. The difference is the display of the weapon. And there are many cases where there isn't. Again, if she had not shown the weapon to her boyfriend and showed that she also had control over that weapon, then I think that this would have been a case that would have been removed to family court. But that display is the display is the difference.
Ms. Field, I'm probably stating the obvious, but I think I'm now thinking more about the Justice Presiding's 2 analogies where it's just on the back by the belt. And it just happens to be seen by an officer driving by. So that's a weapon that was observed. As I understand it, your display is an active kind of verb thing, that is where the defendant displays it.
Yes.
That's how you define display. Now, display, according to your colleague here, is not exactly an issue, but that would clarify it too if we made that clear, that display means not just being observed, but being displayed by the defendant.
I believe it needs to be something acted by the defendant to fit within the confines of the statute. And then this would also fit with the, certain cases are removable, certain cases are not. And that's in this case, there was an active action on the part of the defendant to display that weapon to someone else.
Right. I think we understand. Thank you.
Thank you.
We will turn to case number 302, matter of Shayaya H. We have counsel who is remote and we are ready to proceed. So thank you.
Morning, may it please the court, Sabrina Bremer on behalf of Shai-Danae H. Here there was insufficient evidence to show that Mrs. H's mental health posed an imminent risk to her daughter. Her daughter was removed due to her hospitalization, and medical records showed that her daughter was a well-appearing child. She was in fact appropriately dressed for the cold. She was happy and content. During supervised visitation, she was able to engage appropriately with her daughter. And the statutory test is a minimum degree of care. It's not maximum, it's not best, it's not ideal. And while she has certainly struggled with her mental health, the evidence here is insufficient to show.
There was an issue at that time, though, Counselor, wasn't there? Was no housing for the child?
Yes, she was in a shelter at the time.
She had left the shelter, as I recall. She had left the shelter and made her way to the public safety building. But procedurally, right, the request here was to have the child return to mother during the pendency of the proceedings. And where does that neglect petition stand now?
So the fact-finding hearing is still ongoing. It's been adjourned several times, but now it's been almost a year since her daughter has been in her care. So we are unfortunately in a situation where this still has not been resolved.
Child is in her care now?
No, sorry, excuse me, not in her care. The child is still in foster care, but it is my understanding that she is currently employed, that her husband has come up to Rochester, and they have found housing, albeit in hotels, and that she has engaged in counseling.
If he gets the child back in family court in that proceeding, is this moot? This appeals moot?
Yes, it would be.
Do we have a date on a hearing or disposition?
I believe it's been adjourned, but I think in the next few weeks, it's supposed to resume again.
Are we close to the end of that one?
I'm not sure.
As there are, I think you would acknowledge some of the testimony from Ms. Sherwood, particularly about the voicemails the mother left about Europe invading and somebody from the Ku Klux Klan helping her sister murder somebody and extraterrestrial. She's an extraterrestrial. Things along those lines raise some concerns as to whether she's mentally capable of caring for this young child.
Yes, I do understand that. And I think I would go back to that her daughter was in her care since she was born, and she was able to care for her daughter, and that there were no concerns when her daughter was examined at the hospital.
All right, we'll take a look at that. Thank you. Ms. Whiteside, good morning.
Good morning, Your Honors. Thank you. The standard here is whether whether the record substantiates that that the return would present an imminent risk to the child's life or health. And it is my position that the department proved that. Going back to what Justice Delaconte mentioned, that there was no housing. The mother and child, and was a very young child, 18 months, was in a shelter. The mother heard the visions or voices regarding other women that were staying at the shelter, believing that they had knives. And based on her, delusions of that, she took the child into the snowy Rochester winter with nowhere else to go, and made her way to the public safety building. So that's evidence of her listening to her delusions and making those delusions the primary, she would say the primary guider for how she protects her child. And given all of her very, very concerning statements regarding lists of murders and, paranoid feelings about people coming after her husband, the police, that that the court had ample evidence that this mother was placing her child at imminent risk. And when she was released from the psychiatric hold and was testifying, she was asked, well, when was the last time that you were having these delusions? And she's like, oh, right here, right now in court. They're happening right now. And this is all part of it. So based on the mother's behaviors, and she also said that she wasn't taking the medication as prescribed. She was taking it when she felt like it, and she wasn't engaged in any follow-up counseling, which was also part of the requirements, that the court did have ample evidence to find that during the pendency it was imminent risk for this child, and the mother's mental illness was causally related to this imminent risk. So unless there's any further questions from the court, I would ask that you affirm family court's decision in this matter.
Thank you.
May it please the court, Maureen Poland from the Legal Aid Society of Rochester for the child. She is, just as a brief update, 2 years old. She is still in foster care at this time. And as we heard from counsel for the mother, this case is not yet fact found in family court. They are in the middle of the fact finding hearing at this time. There is a planned permanency hearing scheduled for April 15th. So that is an opportunity to look at the progress that parents have made, even separate and apart from the 1028. It's certainly not true that children always remain away from their parents during these proceedings. We have some children who will potentially be released home with some supervision, even while we have neglect proceedings going on. That simply isn't what has happened here. My client remains in foster care because there continue to be concerns. And I would submit that here, what the court is considering on this 1028 hearing is whether there was a sound and substantial basis in the record for the court's determination that my client would be at imminent risk of harm if returned to her mother's care. And I think that we do have enough here that the mother's mental health, which she does not have insight into, which she was very reluctant to accept treatment for. She was even involuntarily held at the hospital at one point in order to be medicated, that mental health condition is causing imminent risk to my client. When you are taking her, when you're leaving appropriate shelter, taking her out into the freezing winter in Rochester with no plan of where you're
Most
going next.
concerning statement appears to be the allegation. She said she would rather have the baby not on earth than having somebody profit from her, referring to DHS.
Correct.
That one is a big concern if her child be killed.
Of course. And I think that there are these concerns that unfortunately the mother did listen to and continues to listen to her visions and her delusions. And she bases choices for the child on these visions. And she places her child in very dangerous situations because of it.
Do you have any further update on where the proceedings in this?
Well, April 15th is the permanency hearing, and then they have at least 3 other trial dates scheduled after that. I'm sorry, I didn't write those specific dates down. So,
Is there a chance she could be returned on the 15th if she's engaged in services making progress?
my understanding is that there are still some concerns. I don't think that the child would be returned on the 15th, but certainly if that were to occur,
Right.
If
Please
court-
update us. Yeah.
I'm sorry.
Yeah, please keep us apprised.
Of
Can I
course.
just ask you one? Does she see the child at all?
Yes, both parents have visitation. It's supervised visitation. So they haven't even progressed to the point of having unsupervised visits. It is still supervised visits, which is why it seems unlikely that the child would be returned on the 15th.
Thank you.
Thank you.
Case number 304 is matter of Dana DeFlorio versus John Heisler III. Counselor, good morning to you.
Morning, Your Honor. May it please the court. Thomas Babylon on behalf of Appellant John Heisler. The first point I'd like to discuss this morning is that the lower court erred when it reversed the support magistrate's decision and failed to credit John for daycare costs that were paid on behalf of by his family. Issue here is a little over $6,000 that was paid by John's parents for daycare at a time when he was unemployed. It was paid for his benefit. That's what the testimony was. First, it should be noted that at the hearing, the mother stipulated that this money should be credited to John. She was asked by the support magistrate, do you have any objection to us crediting to those terms paid by his parents? She said no. She agreed to it. And after the support magistrate's decision crediting those sums, she filed a formal objection to the entire amount being credited to him, saying that only his 31% of the daycare costs pursuant to the order should have been credited to him. The family court then found, without any evidence in the record, that the sums were not paid by his parents for his benefit, but instead were a gift to the child. This was error for several reasons. First, stated the mother stipulated at the hearing that he should be credited with those sums. Second, her formal objection did not preserve the point for the family court, and that she had only objected to the entire amount being credited to him. I guess in her mind, when she stipulated to it, she was only stipulating to his 31%. Instead, the court gave him no credit for any of the amounts that were paid by his parents. Finally, the lower court's determination that the payments for daycare were gifts to the child were unsupported by this record. Daycare costs were something that were required by the child support order to be paid. The payments were made by his parents. The testimony was at a time when he was out of work and for his benefit. And there's no evidence that submitted that would suggest that these were payments were a gift to the child.
What about a gift to both parents together?
Well, it's funny, because not funny, but that's something that the family court could have, I guess, said that, but there's nothing in the record that would support that. The testimony was that, these payments were made by the father's parents because he was out of work and he was obligated to make these payments.
But he was obligated to only pay 39%.
Yes,
So the parents, we had some text messages, parents could have, or email, I forget how they communicated, but his stepmother could have very easily said, let me know what the 39% comes to. I'm going to pay that. That's not what it said. It said, I'm going to pay the daycare costs.
That's correct. And they also gave him money to pay his regular support obligations at the time, which the court didn't find was a gift to both parents either. There's nothing in here from text messages indicating that was a gift. So if it wasn't a gift, he should be credited with those full amounts. Alternatively, if the court were to credit him with 31% of those amounts, this court would still be required to send it back to the family court, because that's not what was done here. They credited it with none of the accounts. They said, seemingly, I guess, to come up with some kind of theory where he wouldn't be credited with anything. It doesn't make sense that this would be a gift to the child. I agree that they could have found it was a gift to both parents, but there's nothing indicating that from the step parents or from the grandparents saying that this is a gift for both of you. They just said, well, I'll pay it. Basically, we know he's not working. He's not able to pay this. We'll pay it. Let us know what the bill is.
So it was a gift in your view to the son.
Exactly.
But they didn't pay the money to the son directly.
No, they did not.
I mean, isn't that how most gifts are given to the receiver? Here is a gift given to the daycare provider more than the 39%.
Well, they were stepping in the place of the father. If the father could have paid the daycare provider directly for these costs, so they're stepping in
and then making advance payments on his behalf.
Yes, Ron, that's our position. He wouldn't. Obviously, the grandparents were aware he wasn't working and unable to pay these costs at the time. I'm not sure if they were aware of what the obligations were under the order. They did say, "Hey, listen, give us the bill and we'll pay it." Though.
So you want us, assuming we would agree with you, how much is this dispute worth, by the way, like dollars and cents?
It was about $6,000.
Right, but if we rule your way, he gets a credit going forward for future daycare in the amount of?
Well, I believe there would be some sort of calculation by
less than 6.
Yeah, it could be probably. The thing is he also had, at the time of the trial, he also had paid in excess of his regular support amount because he was paying more than was required. He had $800 surplus on his regular support. So this is something that would have to be sent back to be calculated by the family court, Your Honor. I don't know, have the exact numbers right now, and when I looked at them, they were a little confusing to me, to be perfectly honest with you. But it was something that they would have. If this court would have to determine what he should be credited for, and then I think it should be sent back to the lower court.
We could remit it to the court, could do that. We say give him a credit for this. It looks like maybe a few $1,000s if you're right.
Yes. It's not a lot. I think at the end, I think, support magistrate credited him with having overpaid, I think, $200, and the family court had said that he had owed $4,000 at the end of their calculation. That's without crediting him for any of his. So that was a little confusing to me. I didn't have all the numbers in front of me, but they would have to do that calculation to figure it out, Your Honor. The second point I'd like to discuss today is that the lower court's finding that this violation of willful was an abuse of discretion. If it's discretion, a willful finding to pay child support is a finding of civil contempt. Here, proof of prejudice is required, and the lower court strangely found that he was in contempt, a willful failure to pay child support, but also found that there was no prejudice. So you can't have, it was inconsistent. The court cannot make both those findings. If they find that there's no prejudice, they cannot find a willful finding here. So for that, we would ask that the order be reversed on the willful finding. Additionally,
the only consequence of a willful violation here would be the award of attorney's fees, which didn't happen.
It wouldn't, but it's a red mark. You have a civil contempt now on your record. If this were to go back again in front of family court, for instance, and they would say, "Oh, well, this is the second time you're here for contempt, and now we're going to impose larger sanctions this time." So the fact that there was a civil contempt found at all is a red mark, a black mark against our client, rather.
It was undisputed that he didn't report his employment timely. Certainly not within 3 days, correct? That was undisputed.
I don't think it's undisputed at all, Your Honor, because what happened was first the support magistrate said, "Well, we're not going to consider this. We don't want to hear it." But then they still allowed her to testify that well, I went to family court and they told me he's been working since August, which would have been evident to her because she was receiving the child support, it was being taken right out of his check. He still never told me that he has a job. Now, what the support magistrate says, I'm not going to consider this. This is not something you pled. So he wasn't under any.
I was just talking about the fact that he didn't report it in 3 days. That's undisputed.
I'll get to that here. So she never asked him any questions about it. The court never asked him any questions about it, but she did submit a text message from June of that year. It's 2023. My client didn't really remember when he started. He said he thought it was August or September. She said she believed it was August of 2023. She sent him a text that she submitted that said, now that you're working, when are you going to start paying these add-ons, like daycare? So she knew in June of 2023 that he'd accepted new employment. So there's a contradiction within her own evidence there, whether or not she was informed of this new job. He was never asked. He was never given an opportunity to dispute that. So here, especially with there being no prejudice, there cannot be a willful finding. So I would ask that the court reverse that point.
And did the mother allege a willful violation?
She never pled it. Well, she alleged willful, but she's in her allegations were he didn't pay daycare. I mean, this daycare sum that the parents had paid, she alleged she paid and he never paid her back. She alleged on her taxes that she took credit for these payments. And then when she was asked, well, here's these checks with your signature on them, do you accept them? She says, well, there's no proof that I signed them. And the support magistrate, well, your signature's on them and your account information's on them. And at that point, she finally said, oh, okay, yeah, I'll let those be credited to him. So she'd actually alleged that he was in willful violation for not paying these daycare costs that his parents had already paid. This whole thing with him not informing her of employment was something she tried to argue at the hearing. The judge let her testify very limited to about it, but he said he wasn't going to consider it because she didn't plead it. So the judge, they had to conform. The judge did something the support magistrate did not, conform the pleadings to the proof, which is another point where my client was not really given any chance to rebut that for a couple of different reasons. First, he was denied due process here because what the family court did was they initially dismissed the objections as being untimely. And then one day, this is one day after they were filed, they dismissed the initial objections. Then I think a few days later, several days later, they reinstated them without any kind of reasoning or any notice. At that point, 6 days after that notice of reinstatement, they issued an order. So under the Family Court Act, my client's entitled to 13 days to file a rebuttal to formal objections. He was never given that opportunity here, so he was denied due process. If he had been given that opportunity, he could have said, hey, listen, here's a text from her where I she admits that I told her that I had a new job. She submitted this text. So, and there's, other defenses like there's no prejudice here that he could have asserted, which he wasn't given opportunity because he wasn't even under the assumption that this was there was no formal, motion to conform these pleadings to the proof. He wasn't even under the assumption that this was something that was going to be argued. So for all these reasons, I would ask that they order the family court.
Thank you.
Thank you.
Case number 305, University Hill Realty versus Rhonda Eckel and Rosette Ashkerovitz. Something along those lines. Mr. Pierce is going to set the name straight for me, I'm sure.
Good morning, Your Honors. Alan Pierce of Hancock Estabrook for the plaintiff, University Hill. I probably am not going to try to correct the pronunciation, and I'll ask you to forgive my familiarity or my if I refer to the people, my client, the broker, Chris Snyder and Rosette, who had the interactions back and forth, because it's easier and I won't butcher somebody's name. There's really a single issue here in this case. This case has been here before. This court reversed the same trial judge for prematurely granting a motion to dismiss for failure to state a cause of action. And the trial judge here, again, unfortunately, has jumped the gun and prematurely granted summary judgment because he found my client uncredible as a matter of law. Something that's very, very seldom happens. I've never seen it in 40 years of practicing.
Supreme Court seemed to be persuaded in large measure by your client asking for a contract and it not being provided. Is that fair?
Yes, that was one of the 2 points the defendants pointed to on their motion. And the reason that's not, that's certainly something that can be considered, again, by a jury. But here, I think it's important when you look at the timeline. That was it was about January 17 of 2020. We are still within the 12-month grace period of the written contract between these parties. So my client is probably looking ahead that on May 6th of 2020, the 12-month grace period to earn a commission is going to expire. So he's looking to extend and get 6 more months under a written.
It's safer to get it in writing.
Yes.
Doesn't mean that's the only way he can do it, in your
Correct.
view.
And-
Should the focus be on the efforts made after the grace period expired here with the implied contract after May 6th of 2020? There's a lot of activity before that, but
Yes.
it's your argument on implied is after that, right?
Yes.
Okay.
And after that, and just to finish the context, on January 17th, when the defendant, Rosette, declined to do a new written contract, she'd already entered into a letter of intent to sell the property to SU, who was introduced to the property by my client, and they knew that. So there was a good reason for her to decline a 6-month new 6-month agreement because she already had a letter of intent.
They never let him in on that knowledge.
No, never told him that, and never told him to stop sending me offers. So July 2, at least 3 times after the 12-month grace period, it's in my brief, appellant's brief, starting at page 13, it goes through. July 2nd of 2020, Snyder sends her a $4.2 million offer. She engages about it. What's the number? Do you have an actual offer? It's all in the record. It's cited there in my brief. August 21 of 2020, Snyder sends another $6 million offer and a letter of intent. Again, Rosette interacts, exchanges. Is this contingent on anything? Do you have an actual purchase offer? Yes. She then responds, will they need the other properties to sell also? He said it was contingent. September 23, this is what's really amazing. On August 26th of 2020, SU and the defendant sign the purchase contract. Almost a month later, on September 23, my client, through Chris Snyder, sends Rosette another offer of $6.3 million, which is actually more than the SU purchase contract. And she engages again with him about this offer to purchase. Back and forth with emails on the September 23rd and the 24th. This is all in my appellant's brief in pages 13 and 14. Never says, oh, by the way, we have a signed contract with SU. We're not paying you. And we've also agreed to pay SU's broker a 3% commission. We're not paying you your 2% commission. And I think the icing on the cake is the SU broker, David Aiello, even admitted in his deposition that it wasn't uncommon in Syracuse for there to be 2 brokers getting paid a commission, because my client was the seller's broker. Aiello was SU's broker, but the defendants agreed to pay him. And the last piece of the whole puzzle, what's amazing is SU knew about the problem of my client potentially making a claim and asked for indemnification in the purchase contract from any claim by University Hill Realty and forced the defendants to put our commission in escrow from the purchase price because they foresaw this could be a problem.
Yeah, Counsel, just with respect to the point that you made earlier about the credibility determination that the court made on summary judgment, which is unusual and typically not done. The one basis that the court gave for doing that is your client's representation in his affidavit, or the affirmation rather, the August of 24 affirmation. Again, this is 4.5 years after, the January 2020 effort to get to sign up another agreement. But anyway, in that affirmation, he uses the word exclusive 3 times. That he was looking for an exclusive listing, et cetera. And then when you read the actual drafts that were sent back in 2020, it wasn't exclusive. So it sort of deflated what he claimed the basis of his argument. What should we do with that? Well, isn't it fair for the court to look at that and say, wait, that's not consistent?
Well, I get it. He made a statement that was inconsistent with what was in the written, that new contract. And I think that's a credibility issue for a jury, not for the judge. Everything else here points to the conduct and interaction and engagement of the parties as providing an extension of the original contract, which is really the issue, not exactly what was the terms of this potential new written contract. I think that's a little bit of it's a collateral kind of issue. We can all make mistakes. Probably something I should have caught. I should have caught it in preparing the affirmation, but I went on what I was told. I think it was obviously an error, but I think it doesn't go to the heart of the question here about the original written contract and whether there's a question of fact that it was extended by the conduct and interaction.
Right, there's some case law from the first department and other departments that talks about an implied contract may be established in some cases by mere acceptance of the labors of a broker. Mere acceptance of labors of a broker. That seems to be what you're relying on here. It was after the grace period, there's no contractual relationship. Your client is continuing to market the property. Notify Rosette. She, in your view, at that point, needed to express, say, look, this relationship's over.
Mhm.
I'm engaging somebody else. Don't continue to market it with an expectation of a commission here. Is that you need to make those affirmative statements to break off this implied contract theory?
Well, I think it's certainly relevant, Your Honor. I think to sign a letter of intent with SU, who she knew my client presented the property to first.
Within the grace period.
Within the grace period. And not tell him, hey, I'm not signing a new contract because I have a letter of intent with SU. Stop marketing well, he didn't have to stop marketing it, but if she had done that, it would certainly that would cut it off. I think that would be hard for me to sit here and argue if she had said, we have a letter of intent with SU, we're paying another broker. We're not going to pay you.
Yeah, because this implied theory could create problems in the broker relationships where I list my house with a realtor 12 month, doesn't sell it. I go list it with somebody else. The old realtor is still like sending me listings, trying to get buyers. And if he finds somebody, I owe him now all of a sudden. Like, do I have to tell him stop? I guess is what you're saying. Has to be, because that happens a lot in other contexts.
I think it was incumbent on the defendants to tell my client what they were doing. I mean, early on, I forget exactly when, but there was a meeting at the SU Sheridan Hotel. And actually Rosette did tell Christopher Snyder, hey, we're talking to SU directly. And Chris didn't object to that. That was back in, I believe it was in 2019. When he was meeting with her over a different purchaser, either Hutter or Aptitude or one of those. And I apologize, it's in the briefs, I've forgotten exactly. But so she did tell him that she was talking at that time to SU directly and talking to Adam Fumarola. So she told him that. To take the fact that she told him that in 2019, then signs a letter of intent in December of 2019, months later, and agrees to pay another broker and never provides that information to my client, is an issue that the jury ought to hear that about the conduct of both parties. And if I briefly, the second point that the defendants really relied on was a statement, alleged statement that my client, Chris Snyder again, made to SU. Not an interaction between the parties here. That supposedly after SU wanted to offer $2.5–3 million for the property in January of 2019, and that wasn't going to fly with the defendants. It wasn't going to fly. So things ended. And then according to the SU person, Adam Fumarola, my client told them several times, because they were still interested in the property, he told them they signed another deal. It's done. signed another deal. My client says, I did not say that.
Your client admits, though, he led them to believe it was about to sign.
Has a negotiation.
I mean, lying might be too strong of a word. He says posturing, but not being truthful with FU on behalf of his client, perhaps, but.
He said it was a typical, at least commercial real estate, it might be a residential it's a commercial negotiating tool. He wanted to get
It's customary to lie in business, I guess.
He was stretching things. He would to try to get them to raise their purchase offer, which interestingly, they never did through him. And then all of a sudden, months later, they're willing to pay $5.4 million. They went up millions of dollars all of a
It's like
sudden.
there was a relationship between a yellow and.
Yes, a new person at SU's real estate department. Yes, there was a relationship there that we think had something to do with this. Again, we don't know. A jury should decide this. Your Honors, thank you.
Your Honors, Eamon Abraham on behalf of the respondents. May it please the court. Your Honor, you said, you didn't want to use the word lying. Well, you can use the word lying because he said he was lying. I'm going to read a part of the transcript. So why would you tell SU then that they were under contract with somebody else? Because I wanted them to get their number up. My question, so you lied to SU. I'm posturing. My question again, so you lied to SU. On behalf of the seller, yes. He admitted he lied. So before we even get into addressing what's required for implied contract, you have somebody that admitted to lying to SU. Now, the only issue of fact here is whether or not he was trying to sabotage the deal. That is an issue of fact that's irrelevant for purpose of this motion. But the question is, were you trying to sabotage the deal for your friend that you claimed, was going to offer 6.3 million? Now, let's talk about some of the offers that were made. Not one offer in writing during the entire period that he was allegedly representing the respondents. Not one. So they can say, oh, we offered this. There were no offers. There were text messages, Your
I
Honor.
think Mr. Pierce would say these are efforts on behalf of your client. It doesn't necessarily have to come to fruition, but he's working and your client's accepting them. He says under the law, that's enough to at least get you to the jury on implied. That's not correct.
I think Your Honor hit it when you were asking questions earlier about like the slippery slope argument, right? It's a little dangerous when you start saying someone has to tell you, you stop, right? Well, no, because realtors, they're, for lack of a better word, they're hustlers. They're out there, they're pounding, the pavement. They're trying to get deals going. They're going to go and do work, whether or not you or I ask them to, because that's part of their profession and how they do things.
And your client understood that though. And understood that there was the grace period and they had to work their way out of the grace period in order to avoid this secondary commission.
Your Honor, my client never had the grace period in her mind. No, not at all. My client at that point after the
letter of intent was signed during the grace period.
There were multiple letters of intent signed during
With
this
SU.
period. Not with SU, with people, right? That never came to fruition. And if you look at when the letter of intent was signed, I think it took, I don't have it in front of me, I think it took like 9 months to put together the contract. So 4 months after, I think it was 16 months after the initial listing period expired, and then 4 months after the waiting period, right?
What if that was an intentional delay just to get beyond the grace period, as they allege? Would that?
That was never, Your Honor, that was never alleged at any point. And they.
Would that be relevant though to implied contract? We got this letter of intent, but let's hold off on signing the actual contract until after the commission expires.
But Your Honor, you can't get there unless there's an implied contract, right? So you can't even address that question. That's almost like trying to address a fraud claim, right? But you can't even get there without the idea of an implied contract. And I agree with opposing counsel that typically, right? Typically, the idea of an implied contract is better left with trier of fact. But there are circumstances where a court can decide as a matter of law. In fact, this court did in Enfield v. Kingsbury and Sexton v. Amato. 2 cases that the court as a matter of law decided that, they addressed the credibility issue, right? So when Chris Snyder emailed Rosette or texted Rosette and said, hey, it's time for us to sign a new contract. He knew at that point in time, because if you look at his deposition testimony, I asked him specifically, I said, you knew you needed something in writing in order for you to get paid. And he admitted it. He said, I did. I knew I needed something in writing, and that's why he asked for it. And Rosette, it wasn't like Rosette gave him a waffly answer. Rosette was pretty clear in her response. right? She said, we are going to hold off on signing anything until an actual offer comes in.
Right,
Why did
that's
she
the
say that?
best-
Because he's never presented an offer.
Your best argument is the plaintiff, Mr. Schneider, asked for her to execute a new agreement. She said, no, I'm done. Well, she didn't say the words, I'm done, but no. It's tough to say that you then have an implied agreement, you're going to continue the relationship after she refused to sign the written agreement. That's a good argument on your behalf, and I think that's what the judge relied on.
Yes, Your Honor. And the reason why she still, if you want to say engaged with him, it wasn't her engaging with him as in let's sit down. It was her being polite, responding to his text messages. I mean, they had a working relationship prior. This guy does a lot of work in the Syracuse market. She wasn't going to burn any bridges. She didn't just stop texting him. She responded to him. And I think, I mean, it's not in the records. We didn't get there. But if an offer actually would have came in writing for greater than the 5.3 or 5.4 that SU paid, they would have probably taken it, right?
Aiello was not exclusive?
No, he was not. Aiello was not, she refused to sign an exclusive after the Chris Snyder debacle. She just refused.
Doesn't that her statement, we're gonna hold off on signing anything until an actual offer comes in, doesn't that imply that she will sign an agreement with Snyder to continue the listing agreement if an offer comes in?
No, that's her saying, I will sign with you and give you a chance again, but this time bring me something in writing. That's what that is.
Well, so Rachel, she's telling him to keep working. That's the whole point of the implied contract.
No, Your Honor.
Keep going.
And I disagree with that because it's not her saying, keep going, keep going. Her saying is, we are going to listen to offers from anybody coming to bring us the contract, but bring us something in writing and then we will consider it. She was clear.
She doesn't say we're gonna consider the offer. If her actual convention says we're gonna hold off on signing his agreement to continue as the listing agent. They're gonna earn the 2% commission.
But Your Honor, if you remember, the first agreement was an exclusive agreement, right?
Right.
The second one was a non-exclusive agreement. So she could have signed that. She could have signed that with no issue because she was also working with other realtors that were non-exclusive agreements, right? And so the fact that she was very adamant and clear about her response wasn't, as unclear as they want us to think it is. It was, I'm not going to sign anything with you. So I disagree, and I think the lower court got it right. I think it's clear from her mouth that there was nothing. I mean, in order to have an implied contract, the meeting of the minds. Where's the meeting of the minds?
Right, but she could have said, I'm not gonna sign anything with you. Your grace period is over on May 6th. Now, again, this is a month after she's already signed the letter of intent with SU. So she could have said, I'm not signing anything with you. Your grace period ends on May 6th. If we have a contract from somebody you brought me before May 6th, you're gonna get paid. If you don't, you're not. That's the end of it. And then lets the realtor know we're cutting it off.
Well, let's
At that
talk.
point. That's not what happened, though. The opposite happened.
That's not what happened, and I can't address something that didn't happen, right? But what I can address is what we know. But when you're talking about the offer that came in from SU at that point in time, you're talking about an offer that SU wasn't even sure was available to him because Chris Snyder kept lying to him and saying, and whether you take my client's word or SU's word that he said we were already on the contract, or you take Chris Snyder's word saying, I didn't say that already on the contract, they're about to be on the contract. He admitted he lied. So SU didn't feel comfortable working with somebody that was clearly lying, right? Because at that point in time, they went straight to Rosette and said, hey, are you guys under contract? Are you guys under contract? Are you guys about to be under contract? And that's where Rosette was like, no, what are you talking about? And that's where the letter of intent came in. So
why does SU need to be working with him? He's representing Rosette. His relationship is with Rosette. He's going to be paid by Rosette from the proceeds of the sale.
Because
SU, what does SU care?
Because SU knew at that point in time that they weren't working with him. SU knew at that point in time that their contract with him had expired. They knew that.
But he was in the grace period still.
He was in a grace period. Again, he was in the grace period if you're going to assume that there was an implied contract in place, right?
No, it was signed. The grace period ended May 6th of 2020.
But the grace period, Your Honor, required a signed contract. There was no signed contract. Read it.
Right,
and I think that's
but all Justice
period
West is saying is that the letter of intent with SU, not a binding contract, letter of intent was, I think, December of 2019. Within the grace period that expired May of 2020. It was then signed in January of 2020. But that was the judge's point, is that she signed this letter like, okay, we're going down this path. Didn't say anything to Mr. Schneider, even though it was his grace period and he's the one who brought Syracuse to the table.
Well, again, a lot of intent is not a contract, and I think that's pretty clear, right? But the contract that was, I mean, again, in order for Chris Snyder to earn his commission during that grace period, we would have needed a signed offer during that period. I think it's clear that there was no contract within the first 6 months, and there was no contract within the 12 month that preceded it. So in order for the grace period to kick in, we needed a signed contract from SU during that time period, which didn't exist. And not only did it not exist, it took another 4 months to work the deal because the number still wasn't high. And credits to the agent that got it done, he got SU up to where my clients felt comfortable enough proceeding.
Did your clients request an escrow at closing?
No, our SU didn't request an extra on closing. That was, Your Honor.
You requested it.
I said, hey, just in case, we're gonna put something, but that, opposing counsel statement saying that SU knew that Chris, because we had told SU at that point, that, hey, just so you guys know, Chris Snyder's making a claim for commission, because it didn't.
You had to make an assurance at closing to SU that you would cover the claim if Snyder came.
What I told SU was.
You had to tell SU, we're responsible for this.
What I told SU was, hey, just so you guys are aware, there's another agent that's making a claim for commission, but in order to satisfy.
You
you guys,
understood at the closing that the agent was going to be making.
prior to the closing, we told him, hey, Chris Snyder's claiming now that he's owed a commission. We're going to sign whatever agreement you guys want, and we're going to put money aside, but not because SU wanted it. It was because upon my recommendation, I said, before you guys divvy out that money, let's put something aside to make sure that there's commission in the event that we.
You still have that escrow?
No, that's gone. After the case was dismissed, we released that escrow.
All right, thank you, Counsel.
That's right.
Case 307 is Happy Lake House LLC versus James Cross and others. Ms. LaCours, we see you partially.
Apologies, Judge. I'm trying to
Take your time.
maybe a little bit more clearly here. That any better? It is not any better, huh?
You see half of you. You see your full credenza.
I'm moving my camera, but it doesn't seem to be changing the equation at all here. I apologize.
That's okay. The more important thing is that we can hear you.
Okay.
But if you want to take a couple seconds there, try to get your camera right, that's fine. Otherwise, we can just proceed. If you slide your chair
To the right.
to the right, to your right, there you go.
And now look to your right.
And then look to my right. Okay, we'll try this. See if that's a little bit better. Good morning, and I apologize. I'm only offering you half of myself here this morning. So this action is brought on behalf of the Della Santini family, which holds title to Lot 4 on the lake house at Skinny Atlas Lake, and also adjacent property on Lot 5, which is really the subject of this dispute. So the family commenced this action in 2024 with the hope that it could resolve once and for all disputes that really have simmered for some time over the ownership of Lot 5. Lot 5 is a common use right-of-way driveway that is, it is the shape of a Y-shaped parcel, which we showed in our brief on page 6. You can see it in the
Counsel, if I could just cut you off, maybe cut to the chase a little bit.
Sure.
The word otherwise that's used in the 1971 Lombardi stipulation and order, why doesn't that cover the rights that were referred to in the 1968 deed from the Appellhoffs to Lombardi, so that this is essentially over and done with?
Well, the short answer, Judge, is that is obviously modifies the antecedent, and the antecedent is by adverse possession or otherwise. And basically that stipulation has to be read in the context of the litigation in which it arose. And it's the defendants who submitted materials related to that litigation into the record. I would, reference to the court to the bill of particulars in that litigation and to the complaint in that litigation If you go look at the bill of particulars, which appears on page 77 of the record, you'll see that Angela Lombardi, who's a predecessor in interest to the plaintiffs here, identifies two theories. One is adverse possession by virtue of the classic, right? The continuous, open, notorious, and hostile possession of the property, which is the waterfront portion of Lot 5. And she's stacking her possession on two previous owners going back to 1945. So, we're all familiar with that very classic adverse possession claim. But there's a second adverse possession claim, and it's an adverse possession by virtue of a claim under a written instrument. And that is this also meaning language, as I've dubbed it, which first appears in the chain of title in a 1952 deed, and appears in the deed to Angela Lombardi. That also meaning language, we're not relying on that. Plaintiff is not relying on that in this case. But that also meaning language was basically, putting into the deed language that was codifying the adverse possession claim, right? So those were the two adverse possession. And so in the context of when
I'm looking, just hang on one second, before we jump to the 1927 map. I'm looking at page 78 of the records, where there's a claim for the right of way in Lot 5 by virtue of the reference in her deed. And then she talks and chain of title, et cetera, going back to the 1927 map, but the reference in her deed is the 1968 deed. So she did make a claim for that, and then she,
well, it's the
1968
deed, Judge.
in settling it, she said, I waive any and all rights or otherwise. Basically, she's referring back to the claim that she made in this action.
Well, Judge, I think that's, that's one interpretation. I don't think it's the only reason.
Counsel, let me, Counselor, frankly, I'm having trouble hearing you. So if you could inch closer to your microphone, that would help me. But at the same time that your client settled, or not your client, but your client's predecessor settled that claim, she also took an easement over the property. And Judge Murphy made it pretty clear that if she had a right by title, so a right other than by virtue of adverse possession, taking an easement right would be inconsistent with that claim. And that was part of his analysis in trying to understand and unwind what happened in 1971. I think what you're arguing here is you have some kind of claim over, we'll call Lot 5, the triangular Lot 5, by virtue of a transfer of rights in the 1931 deed. That's essentially your argument here, isn't it?
That's right.
Right. But Judge Murphy said in some ways that's inconsistent with the 1935 deed, where your predecessor, there was a conveyance of Lot 5, the triangular lot, out, separate from your alleged claim that it was included in the 1931 conveyance.
Oh, respectfully, Judge, the 1935 deed is not in our chain of title. That 1935 deed is after.
No, it wouldn't be. It wouldn't be,
right,
because the 1935 chain would have included Lot 5, and Lot 5, that's the issue here, is Lot 5 in your chain of title.
Right. The 35 deed sheds light on the intent of the 31 deed, but your argument is that the 35 deed wasn't even submitted below, and the court reached that sua sponte. But getting back to the res judicata issue that Justice Nowak raised earlier, the settlement issue, I should say. I understand your argument to be why that settlement doesn't foreclose the claim here is that the claim is different. There was adverse possession, maybe a claim by written instrument on other deeds. At no point did Lombardi mention this argument, this interesting interpretation of the 1931 deed, this language that you rely on, the conveyance is intended to convey a part of the premises that were conveyed from Foltz to Smith to Burnett and so forth. That's your argument, right? Is that this 31 deed based claim was not part of the lawsuit that was commenced in 69 and settled in 71. Do I have your argument right?
Absolutely. It very clearly was not that claim. And I think that helps shed some light on the language, the careful language that was chosen in that stipulation. If there was just a broad-based claim, a waiver of any interest in the waterfront part of Lot 5, they would have just said that. Why would they put in?
If you're right on that, in your view, could Ms. Lombardi, after signing that stipulation and getting that letter from Judge Hancock, everyone's good here. They were going to trial, I think, that day. They settle any and all claims. In your view, the next day or the day after or the year after, Ms. Lombardi could then sue again, claiming 1/3 interest in Lot 5 based on the 1931 deed, right? That's your view, that she could
Yeah,
do that.
If she didn't waive it, and there's maybe a question as to the good faith of doing something like that. If we're making a res judicata argument, right, that might
Right.
come into play.
Because
If the other side is, but it's not, in terms of what was waived or taken out of the chain of title coming to our plaintiff, I think the stipulation has to be read according to its plain terms. And sense has to be made of the decision to include, to very specifically note that she is waiving the adverse possession claims. And I would also like to point out, Judge, that she had won in a trial against the other defendants, right? She had won. So why did Ms. Lombardi, agree to settle, even though she had just won at a trial and probably would, unless something major had changed, might have prevailed again? And I think the answer is peace. I think that Ms. Lombardi was seeking
She did get
peace.
a stipulation that they weren't going to build on the lakefront lot 5, and she got that easement, the permanent easement there. But with res judicata, let's say that, because you appear to be right. I looked at the complaint, Lombardi's complaint, it doesn't raise this 1931 deed issue. But res judicata encompasses claims that were made, not just were made, but could have been made, right? It's broader than that. And this claim, I don't think Lombardi thought of this claim in 31. I don't think anyone until you and your client came around. It's kind of a novel interpretation of it. I'm not saying it's wrong, but Lombardi had no idea of this 1931 based argument. But it could have been raised. If it's valid, it could have been raised in her lawsuit, and it wasn't. Would not res judicata then encompass it?
Well, typically when there's a settlement, right, and this isn't a case that went to judgment on the merits, and we have a conversation on res judicata. This was a settlement agreement, and this and under that theory, the settlement agreement would be meaningless. That would be meaningless what people said and agreed to waive in their settlement agreement if at the end of the day we're just going to say, oh, they could have raised the claim and they didn't, right? So I think we have to give effect to the language in the stipulation, and I don't think the other side is arguing otherwise. The other side disagrees with what is a reasonable interpretation of the stipulation. We would say at worst the stipulation is ambiguous, which is yet another reason why summary judgment shouldn't be granted. We certainly think that there has to be some understanding of why they framed this language this way. It doesn't make any sense if this was just a waiver of ownership rights over the waterfront at Lot 5. They would have just said that. Why did she waive specifically these claims? I think the stipulation itself presents, I think, a pretty significant question as to what the intent and what was meant. And the context is important. We have some of it in the record because, interestingly, the defendants put some of those materials in the record. But I don't think you can look at this record and be absolutely 100% sure. And this kind of brings me back to the point that I was sort of going to second what the previous appellant in the previous case said. I think there was a jumping of the gun here. I think the conversion under 3211C here was an error, and it was an abuse of discretion. And I'm going to say that the Supreme Court justice below did not have the benefit of this court's recent decision in Barker v. Javera, but I think it's pretty clear from that decision, from your 2025 decision, which came after the decision below here, that that's a pretty drastic remedy. It shouldn't be used if there hasn't. And this is a pre-discovery, right? Pre-answer.
Right. What discovery? Your claim in the complaint is based on that 31 deed, the third decretal paragraph there. It seems like the entire claim of ownership is based on the 1931 deed. I get where there may be discovery relevant to the settlement from Lombardi in 71. What do people intend? But let's go to your claim. Your complaint says my client's entitled to 1/3 ownership in lot 5, the whole lot of it, the Y, the field goal, if you will, field goal post, based on the 31 deed. What discovery exists in the possession of the defendant or anywhere else that would shed light on the 31 deed? Nobody who signed it or was involved in that is going to be around anymore.
Well,
What exactly would you be looking for in discovery here?
Well, let me just just sort of put a procedural point on this, which is that this is defendant's motion for summary judgment. So before we get to my case, they have to meet the burden on their case, right? And they have to show basically that somebody has a superior interest in lot 5. And so far they have not done that. So I don't think that the burden ever shifts to us. And it's true that the 1931 deed is not a model of clarity, it's fair to say, but without having conducted discovery, I think it's hard to say there is nothing that would shed light on it. And I'd also
what conceivably could be out there that would shed light on the intent of this 31 deed?
Well,
no other parties today will have any idea what they meant back then. I don't think anyone alive would.
That may be true, but there may be other events in the chain of title and even outside the chain of title that might shed some light on this. And let me say, like, for example, right, somebody must own lot 5. And yet we don't have, you would have expected that a documentary evidence motion to dismiss would pony up a deed indicating who owns lot 5. And what we got was a 1984 quitclaim deed, that basically says, a bunch of the predecessors and interests of the defendants get whatever they already have. That's what it says. It doesn't warrant anything. It basically says, they get whatever they already have. This is just to clarify that. And similarly, we have a 1984 quitclaim deed. We have allegations that there's 2 associations and one owns one parcel and the other owns another parcel, but we have no deed into either of those associations. The only deed we have is into yet a 3rd association that is not referenced in this LaFrance affidavit, which is, to the extent there's any description of what's going on, it's in that affidavit submitted by the defendants. So, I think it's hard to say when you haven't had discovery that nothing else will shed any meaningful light. And here's the thing, this could, I think what happened below is, when you have 10 pieces to a puzzle, you may think that's all you have, and let's just make sense out of putting the 10 pieces together and make some coherent, story out of it. But it could be a 100-piece puzzle, and we've only got 10 pieces.
One piece that could shed light on it is the 1935 deed with respect to the other lots. And
but the
judge did
1935
rely on
deed
that.
is 4 years later. So I don't know how we can rely on that deed to tell us what is in this deed. And I just want to make a couple of points about some of the arguments that are being made here. And it relates back to one of the points you made earlier, Judge, about whether what kinds of interests can be in the same deed. Supreme Court below concluded that, it was incompatible to have, for example, a right of way and an ownership interest. And I'm just going to point out, for example, the 2012 deed that it's at page 172 of the record that I would have the court look at, which is the deed into the defendant who is said to be the representative defendant, right, who owns lot 5. And that's a 2012 deed, which has both basically a right of way in it, gives a right of way over lot 5, common use of lot 5. It also purports to give a right title and interest to lot 5. But then at the bottom of the deed, it says, but we're not warranting title to lot 5. So, it's hard to argue. I think you'd have to look at all the deeds with respect to this tract to figure out whether it is in fact inconsistent. Because remember, we have a whole bunch of families that are each getting a little piece. They're getting a right to use lot 5. And maybe they're also getting some little piece of title to lot 5, although there's no warranty anywhere that has been submitted so far warranting title to lot 5 in any of the defendants. At least we are starting out with a 1931 warranty deed that we have that going for us. So I think when we look
Counselor, if we could go back to your argument here, your position is the 1931 conveyance transferred to your predecessor a 1/3 interest in the entire Lakeview subdivision.
Respectfully, Judge, that's not our position.
Lot 5, the entire lot 5 with the stem, right?
But you're relying on, you're relying on, sorry, just a slow.
Yeah, no, fine.
But you're relying on the together with language.
No, that is sort of a straw man that has been argued that we are suggesting there was some omnibus transfer in the 1931 deed. We're not arguing that. We're arguing that the language in the 1931 deed has qualifiers in it. It says a part of the premises. It refers to the premises previously conveyed therein. So it's qualified. The language is qualified to refer back to lot 4 and lot 5, which are referenced earlier in the deed. So there's no argument that everything that Shotwell had was conveyed in this deed. In fact, that is certainly not the case. There was,
but that doesn't seem to make a lot of sense because it says this conveyance intended to convey a part of the premises which were conveyed herein in the prior two paragraphs. Well, lot 4 was already transferred in its entirety. So why would they need a 1/3 interest? Because
it can only be referring to lot 5, Judge, because lot 4 was already. So if the first paragraph,
well, they
conveys
they
lot
didn't
4.
convey, but the prior paragraph doesn't convey an interest in ownership in lot 5. It's just a right of way for a driveway that's specifically described in the deed.
That's right. The ownership interest is not conveyed in paragraph 2. It's conveyed in paragraphs 3 and 4. When there's a reference to whatever Shotwell had, right? In respect to the portions of the property previously referenced in the deed. So that's.
You would agree with this much. You would agree with this much is that it's what you're arguing. Your interpretation is not at all clear. Matter of fact, Lombardi's had no idea that this didn't even make this argument because it never occurred to them. Doesn't mean you're wrong, but it's a very clever, some would say maybe strained interpretation of that language.
I would say this to you, Judge. We don't know what Lombardi thought or why Lombardi chose to do although, it would be nice to depose her. We would have liked to depose her. We'd like to depose Mr. LaFrance, how he could explain, his arguments about who owns lot 5. We have not had any discovery, but let me just say this. It's not clear there will be anything. This is not a model of clarity, but it's not clear there's going to be anything that is a model of clarity about lot 5, because as I previously noted, defendants did submit quite a few deeds related to lot 5, and none of them, right, clearly say we're conveying warranting ownership to lot 5. And so, if this were to happen today, if this subdivision were to happen today instead of 1926, there would have been a homeowners association that probably would have been deeded, ownership of this common right of way, and everyone else would have been deeded, a right common use or right to use, right? That's probably how it would be handled today. It wasn't handled that way. And it's not clear when other folks got, to the extent of other folks got an ownership interest in lot 5, when or how that happened. We just have we have a warranty deed from, 1967, which is right about the time the Lombardi issue was heating up. They went and got a warranty deed, a quit claim deed, which basically said, I'm not warranting title, but I agree you have whatever you already have in terms of ownership of lot 5. And we don't have anything, showing what they already had. So it's a little bit, difficult to look at this deed and say, yeah, this isn't clear. There's nothing, I don't know that we're going to have clear. And that's why this is a case, I think, that really needs discovery. It needs perhaps some experts to go back and look through this record and figure out what was going on. Now we're up to 100 years. And let me just make this plea. When this issue arose 50 years ago, unfortunately, the question of who owns lot 5, which was raised, and by the way, defendants in the Lombardi litigation, the predecessors in interest, counterclaimed for a statement that they own lot 5. They didn't get it. And I guess if we're going to talk about res judicata, we could ask whether they have the right to assert now that they own lot 5. We're not making that argument because we think it has to all come down to the stipulation. But the point is that issue was raised and it wasn't resolved. And now here we are 50 years later with issues still simmering and sometimes erupting with respect to who owns this lot and who has the ability, maybe even more importantly, to control the use by others. And there are many, many people who are using this common area. Nobody is trying to oust anybody from use. Plaintiffs certainly are not. It's just there's many people using this lot, and it would behoove, I think, it would be helpful if we could resolve who owns it so that we don't have more litigation about this in the future. I just think we've short-circuited. We've used an unusual procedure. What is the harm, right, of using ordinary procedure, doing discovery, seeing what's out there? Maybe we can figure out this mystery and resolving it for the benefit of all these people. Because right now there's people who are assuming things, they're perhaps misinformed, and they're acting on those assumptions. And it's really, making it difficult for this family to enjoy the property everybody agrees they do own, which is lot 4. It's really been a very, very difficult situation. So I think maybe at the end of the day, there'll be a determination that Ms. Lombardi did waive. I think that's a very tough argument personally.
There might be a determination that the 31D did not transfer 1/3 interest.
That's entirely
For the
possible,
process.
Judge. But let's not do it on an incomplete record. Let's do the discovery. Let's litigate the case using an ordinary procedure, and try to resolve this for these people. To resolve a dispute that has just continued to persist despite what happened during the previous litigation.
Thank you very much.
Morning. May it please the court, Matthew O'Neill, Costello, Cooney, and Fearon on behalf of the respondents. Justice Lindley, as you are well aware, I'm intimately familiar with the court's decision in Barker versus Guevara, having argued it twice before this court. And my understanding of that court's holding as it relates to the procedural argument that the plaintiff is making is in that case, there were allegations of fraud and misrepresentation that predated the agreements that went to the effectiveness of the deed itself, not the interpretation of the document. And so I think we have to go back to the baseline rule under New York law that where the deed is clear and unambiguous on its face, that interpretation holds and extrinsic evidence should not be brought into the record.
You think the 31 deed is clear and unambiguous?
I believe that it is. I believe we have the first paragraph has a property description for lot 4 and conveys the entire fee.
Yeah.
The second paragraph conveys a right of way between Westlake Road and lot 4, and it has a clear path and a clear purpose. It is a right of way. It does not convey any right of use or of lake access over the lot 5 area.
Right.
And
it's an L, not a Y, in your view.
It is an L, not a Y,
So
of
then
its express term.
It's the third paragraph, though, that they hang their hat on.
It is. And in that third and fourth paragraph is a genealogy, if you will, of Shotwell's estate. Because in our review, we're not aware of there having been any deed from Shotwell to his estate or anything that cleaned up how it is that these 3 representatives have title or have the ability to transfer. Because this deed was, as the court is aware, between Barnett and Shotwell's estate. So you have 2/3 there is no dispute, are transferring their interest under paragraph 1 and paragraph 2. And 3 and 4 serve to explain how it is that these 3 individuals who weren't on the prior deeds have authority to transfer a part of the premises that was provided to Shotwell.
It deals with the quality, not the quantity of the property. It's
Precisely.
not descriptive. It provides some understanding to the title examiner where their authority comes from and to clearing up the title.
There is absolutely no description of any property rights in those paragraphs. It only says that their ability to transfer the premises therein. What is the premises therein? We look to paragraphs 1 and 2. the parcel of lot 4 itself and that right of way between West Lake Road and lot 4. To say that somehow that title therein, it gets transformed to actually mean a co-tenancy, really stretches the language. And
Would you, is there any explanation for giving a right of way over the driveway, the L portion of that driveway, and then granting a 1/3 ownership interest? Is that inconsistent with?
I would agree that it'd be inconsistent to have be a tenant in common, have a full right of access, not simply to the L shape, but under plaintiff's theory, the entire Y shape, and then have to spend an entire paragraph describing what path they're allowed to take.
In your view, that third paragraph, if that is, as Ms. LaCour says, argues, grants a 1/3 interest in lot 5, the entirety of it, it renders superfluous the right of way in paragraph 2.
It would, Judge.
In your view.
In our view, and also it would require a reading into lot 3 of where is the property description? Where is the description? Where's the description of these rights? Why doesn't it say co-tenancy? Why doesn't it explain why in one document we have 2 ownership groups, one of which is conveying a 2/3 interest in a parcel, and one of them is granting a 1/3 interest in 2 parcels. There's nothing reconciling a very strange conjunction of such a deed, and it pushes. And further on, and there was very little discussion of the easement rights. I would say on this record, should the court find that there's no conveyance of a 1/3 interest in 1931, the right of way over lot 5 or over the driveway is unambiguous, and it is defined with the purpose and path.
Is there some ambiguity that we don't have that westerly lot line over the top of lot 5? When we look at the map, I mean, that's part of that. The petitioner's position here is it hasn't been established as a matter of law that it isn't a goalpost, that lot 5 doesn't include what we're also calling the driveway parcel.
Judge Del Conte, under New York law, when an instrument grants an easement, and we look to, for the path and purpose of that easement, we look to the original document of the conveyance, which is 1931. We only look to the map in which it references, if that path is not specifically defined within the property description itself. And for that, I would cite the Terwilliger versus Steenberg, 3383D 111. And in that, we have, within that second paragraph of the 1931 deed, a defined path that while we do have a reference to the map, it tells exactly where they're able to go, and that would cut off the ability to use the rest of the parcel. So my understanding is at some point between 1935 and 1968, there was a subdivision of that Y shape, and we have the modern configuration, as well as the northern portion above lot 5, and it becoming the backyards of those northerly parcels. However,
do you have any proof of that subdivision in the record?
That proof with regard, the subdivision itself is not specifically evidenced in the record. However, there is in the record the tax maps showing the modern configuration of the parcels. And at the end of the day, the respondent's position is not based on the existence of a subdivision, although that is discussed in the court below's opinion. The key part is that we have a defined easement in terms of path and purpose in that easement, and they cannot, there is no right to the remainder of the parcel when we have a specific defined easement.
So who, Ms. LaCour has raised the legitimate issue of who owns lot 5 or the 2 lot 5s, the lakefront lot 5 and the driveway lake 5. I know there's a Lakeview Lane Road Association and there's a Lakeview Lake Association. But where did they get it from? Who owned it back in the day? By name?
Well, so both of those parcels are currently owned by a representative association member.
Where they get it from?
A chain, I believe it was a chain of title that would track back, my belief is into 1935. However, Judge Lindley, the court made no determinations as to that particular title, nor was it asked to. The question was whether there was a 1/3 interest that passed to the plaintiff's predecessor in interest. There isn't, and frankly, the respondents are in this lawsuit because they were sued as folks who had property interests in this property, predominantly by easement in their capacity as association members, and they each have an easement in their deed. On appeal, they're now suggesting that they somehow don't have standing as easement owners to challenge this 1/3 interest. And respectfully, no authority for that position was raised below and was not raised to this court.
What do you say to her argument that the decision doesn't apply the standard burdens of proof on summary judgment? The moving party may establish as a matter of law entitlement judgment. If they make that burden, it switches. The court instead seemed to just be making findings of fact like it was a bench trial. That's the argument. Do you read the decision as applying the summary judgment standards properly?
I do, Judge. I read the decision as getting it precisely right in this matter. This case and the defendant's prima facie showing comes down to two documents: the 1931 deed and the 1971 settlement agreement. And the court applied and interpreted that document, or those two documents, and found that that made the prima facie showing, at which point the burden shifted to the...
Let me stop you there, because at the beginning of the decision, portion of the decision, it says plaintiff has failed to establish as a matter of law that it has an ownership interest in lot 5, has a right of way over lot 5, so forth and so on. Plaintiff failed to establish as a matter of law. Her argument is we didn't move for summary judgment, the defendants did. They have the initial burden. Her argument is that the burdens should be different. The court didn't apply it correctly.
Judge, I think that while it could be that on a rewrite, Judge Murphy might have reworded that sentence, I think if we look at the overall structure of the decision, the court takes notice of these two documents and then finds that there is no question of fact as to their whether or not they are ambiguous, and that there's no further need or appropriateness for further discovery. And I would respectfully say that the judge applied the correct document, considering that, again, given the lack of extrinsic evidence and the lack of ambiguity within the documents themselves, the prima facie burden was established by the respondents. Briefly, with regard to the 1971 settlement agreement, as counsel noted at the end of her argument, there was, in fact, a broader context to the 1969 to 1971 litigation, in that there was a counterclaim wherein the defendants sought a declaration of their ownership in the entire fee, and the lawsuit as a whole was dismissed with prejudice. And I would respectfully say that given that broader procedural context, res judicata would apply to the plaintiff's successor in interest, then trying to relitigate whether or not she had ownership interest outside of the very clear and specific property rights that were granted in a 5-page settlement agreement. And with that respect, I submit that this is a highly specific agreement granting a lifetime license, a permanent easement, and multiple stipulations with regard to future development of the parcel. Would be bizarre for Ms. Lombardi to consciously think that she has a 1/3 interest and not preserve those rights within the settlement agreement. And I speak to, frankly, as the court recognized, probably it's unlikely that any such interests were ever considered prior to 2024. But further, if we get to the waiver of rights in the last page, we have on both ends of that sentence language that is implied by New York courts to require maximum breadth in the term. We have at the front of the sentence, any and all rights with regard, and then finally at the end of the sentence, or otherwise. And I think we read that sentence as a whole, and then put it within the context
Yeah,
of,
you're leaving out adverse possession in that sentence.
we're leaving.
You just did, I mean, that's.
Correct.
part they rely
I'm
on.
saying adverse possession is sandwiched in between two, not just or otherwise, but also any and all rights.
But Counselor, if she had, if assume they're correct, that they have title rights by virtue of the conveyance in 1931.
Mhm.
You can't waive those rights. If you have title rights, you would have to grant or release those rights. You just can't waive your title rights.
The settlement agreement
Doesn't use language of release or grant or quitclaim or anything of that nature. If she had rights by virtue of the 31 deed, correct?
So our argument before the Supreme Court was that the settlement agreement, being a written document between the interested parties and filed with the county clerk, which is where it is, does satisfy all the requirements under New York real property law to satisfy a deed. And if such rights existed, it would be a satisfactory conveyance.
Because today we might put in a settlement agreement law of that nature that Lombardi, as part of this, releases and quit claims to the respondents or the defendants in that case, any rights that she may have. That would have cleared it up for sure as to what she intended to do at the end of that case.
I agree that the word quit claim isn't there, and largely because no one in 1971 thought that these rights existed.
I mean, it couldn't have been more that she wasn't transferring any interest, it was transferring, she's waiving any claims that she might have an interest. It's just a claim at that point, it's not an actual interest.
Given that the genesis of plaintiff's argument is this very convoluted construction of the 1931 deed, I would agree that her interest would be in the nature of a claim rather than a concrete property right, and therefore would be subject to waiver under the settlement agreement. And to that, and again, I just go back and say that we took painstaking time going line by line through that third and fourth paragraph. I don't see anything that suggests that it is conveying a right that is extrinsic to paragraphs 1 and 2.
That's the bottom line.
That's the bottom line. These rights never existed. We believe that there is an effective settlement and effective res judicata, but at the end of the day, there's no substance to the claims from the beginning.
Thank you, Vince.
Thank you, Judge.
Case number 308, Koff versus Lawson.
Morning, Your Honor. Stephen Lucia on behalf of the appellant. Judges, I'm not going to belabor what's in my brief. I'm sure you've read it, and I'd be happy to submit unless you have any specific questions for me.
Your argument essentially is that the plaintiff, this is not a dart out case where the driver has no opportunity to avoid the collision. There are dart out cases, and we've granted summary judgment to the defendant. This, in your view, it wasn't a dart accident, run and then boom, it was cross 2 lanes of traffic, cross the median, and then got hit, providing enough opportunity for the defendant to possibly see your client and evade like another driver did. That's essentially what you're arguing.
That's right, Judge. If the testimony that you are referring to, the third party witness says that he swerved to miss the plaintiff, and there was a period of 10 seconds that passed before he then saw the impact with the defendant's vehicle. The other issue along those lines is that the defendant, when she testified, really didn't remember anything at all leading up to the accident, other than she said last second she sees a blur, and that she had no time whatsoever to put on her brakes, and she didn't put on her brakes until she actually felt the impact. And contrast that with her mother's affirmation, where her mother said she felt her daughter begin to slow down, took her foot off the accelerator, heard some yelling, then felt the brakes and the impact. So my position, you're correct, Your Honor, it would be that she did have adequate time to at least swerve. The other individual said he saw her, the third party witness said he was able to see the plaintiff and swerve to miss him. So it is our argument that
you recognize comparative fault as Mount Everest for you at a trial, highly intoxicated, doesn't remember anything, running out against no right of way. The other driver was was sober, passed all of her field sobriety tests. But in your view, that's a question for the trial. The jury may say your client's 99% responsible, but at least you get the one.
That is my view, Judge. Yes, absolutely.
And I just have one question for you. Did the eastbound driver who almost hit the plaintiff, did he blow his horn?
There's nothing in the record that says he did, Judge. He said he swerved. Now, whether you're on seeing him coming and you can see that his headlights swerved because it was dark, should she have seen that swerve maneuver?
Yeah. That's my question. Did the defendant have a common law duty to kind of see that, what she should have seen?
Right.
All right, thank you.
Thank you.
Good afternoon, Your Honors. I think you can hit the nail on the head asking about whether plaintiff says this is a dart accident. And certainly they take the position it is not. Ms. Lawson has proven that in fact it is. There's no dispute the plaintiff was running. So unlike the Utic case where he's walking, and you have a similar actually setup in 2 lanes of travel in each direction plus a turn lane, no turn lane here. They're after a CMAC concert. They're down in the Canandaigua area. It is pitch black. The plaintiff doesn't deny that he ran out with no crosswalk. The horn was, Justice Ogden, not hit in time because what that witness said when we asked him questions about did he hit his horn, it happened bang, bang. It was quick. Bang, bang. He veered to the right. So he was going in the easterly direction. Miss Lawson was going in the westerly direction and the plaintiff was running north. So he jumps out of the bushes. And that driver going in the easterly direction, he actually swerved a little bit to the right. So she wouldn't have seen that. And what Ms. Lawson did in this situation is she submitted on her motion for summary judgment why she did not see the plaintiff. So the question is, did she see what she should have seen? And she demonstrated that she could not have seen the plaintiff. So different vantage point for the eastern driver who's coming up with a positive grade and the headlights would go like this. Different for Ms. Lawson, who's at a negative 5% grade. And so her headlights are going down like this. So you're not having a situation where she could see, and nobody contests with evidence anywhere in the record that she should have seen him sooner. It's pure speculation. The experts have explained it. Ms. Lawson met her burden of proof. Respectfully, Your Honor, we ask that the lower court's decision be affirmed on all counts. Unless there's any other questions,
Thank you.
Smith.
Case number 309, Schwarzfigure versus Cleveland. Case 309. Good morning. We're going to wait for opposing counsel who's appearing virtually. Mr. Gascon is with us now. Counsel, you may begin.
Yes, good afternoon, Your Honors. May it please the court. My name is Thomas Davio with Sugarman Law Firm, and I represent the appellant in this matter, Christopher Cleveland. We are here today to ask the court to reverse the trial court's decision and to grant Mr. Cleveland's motion for summary judgment.
Your arguments are all designed around claiming that you proved as a matter of law that your client was not negligent, and that even if negligent, that your client was not a proximate cause of the injuries.
Yes, Your Honor, that is correct. The crux of this appeal relates to the word temporary, and it is our opinion that the trial court improperly used the word temporary consistently with dangerous. Mr. Cleveland was entitled to summary judgment because there's no world that exists where Mr. Cleveland or any reasonable person in his position could have understood the word temporary as meaning unsafe.
Now, attached to your papers, you attached the deposition transcript of the defendant, correct?
Yes, Your Honor.
And in that deposition, is it fair to say that the defendant tried to blame your client?
Yes, Your Honor.
So we have to consider that testimony as part of your motion papers.
Yes, Your Honor, and that is included in the record. But I think that an inconsistency with his testimony where he's trying to blame our client, the bottom line is at the end of the day that my client, Mr. Cleveland, he did not create the condition or have Okay. I think what I was saying was that he did not create the condition or have actual or constructive notice of the condition's existence. The whole time in that deposition, yes, Mr. Swartfigger maintains that the stairs were temporary. My client, he accepts, yes, the stairs were temporary. Temporary does not mean dangerous. Temporary just means something which is going to be finished later.
But doesn't the defendant blame your client, or at least in part, for the decision to just use 2 screws?
Yes, Your Honor, he, at least in part.
And is it those screws that let loose?
Yes, Your Honor. What happened was those screws were insufficiently affixed. The way that the screws were affixed was unbeknownst to my client. My client had no idea how far those screws were put in, what the length of those screws were, and to what effect those screws were working at.
But he didn't want more screws. Couldn't there have been, with their suggestion more, but your client aesthetically didn't like how it looked?
Yes, at one point he does make an aesthetic preference. He indicates that, he thought the screws might look differently the way that they were screwed in. However, in that same exchange on the record, on that same page of the deposition, my client specifically asked, are these stairs properly affixed? Mr. Swartfigger, the contractor, he asserts at that point that, yes, this is how I do stairs. This is how I typically install them. My client had never installed stairs before. He was not a construction manager. That's referenced. There is one point in the record where he refers to himself as a construction manager. Taken in full context, he's not saying that he was a construction manager. He was asked whether he was a general contractor. At that point, he was trying to distinguish himself from being one. And he said, I was more of, if anything, a construction manager. What he meant by that was he was the homeowner. He owned the home. If he wanted things to get done in the home that he was unable to do on his own, then yes, he needed to pay someone else to do it.
The defendant was not the general contractor, correct?
No, Mr. Swartfigger was a contractor who was hired to perform HVAC work at the property.
Right. And so for how long had the defendant's work been completed before the accident?
Approximately 2 weeks, Your Honor. At that point, Mr. Swartfigger was going to come back, though. It wasn't actually completed at that point. He had finished the work on the first floor and the basement floor. He needed to come back at a later point to finish the HVAC work upstairs.
So his work vis-a-vis the stairs was completed with the understanding, according to deposition testimony, at least by the defendant, that your client would complete those and make them permanent, which would include supporting the stairs, correct?
Well, to an extent, Your Honor, but what happened was my client, whether or not my client was going to finish the stairs had no bearing on the dangerous condition. Mr. Swartfigger attempts to say something to that effect, but the bottom line is that he never directly told my client, who had never installed stairs before, what the difference between a temporary installation or a permanent installation even entailed. My client had no idea.
Do you believe that the testimony of Mr. Swartfigger was limited to just saying, look, these are temporary, or did Mr. Swartfigger also provide warnings that there should be additional fasteners?
No.
And that your client assured him that he was going to finish the stair installation and provide the right fasteners?
So, Your Honor, there is one point, and respondent points that out in their brief, where they acknowledge that Mr. Swartfigger says in his last conversation with my client that you may want to put a couple more fasteners in that. There's no more elaboration behind that. There was nothing that was outlined before why there needed to be additional fasteners. And there was nothing which was described to him which entailed what a permanent installation would entail. My client had never installed stairs before. He was not a construction person. So yes, Mr. Swartfigger says on his way out that you may want to put a couple more fasteners in that. Well, Mr. Cleveland had previously inquired as to the aesthetics. As far as he knew, those additional fasteners, the questions that my client had about the fasteners were related to the aesthetics on the project. As Mr. Swartfigger represented that to him, it could have just been to the extent of the aesthetic of the project.
Remind me, because I don't recall the answer. Did Swartfigger also suggest, Mr. Cleveland, that he have some support under it, the way that Mr. Swartfigger had when he was there?
No, Your Honor, he never did. That was concealed from my client. My client specifically asked, because although not a construction man, he inquired with Mr. Swartfigger as to whether the stairs needed to be affixed or braced by something at the bottom. Mr. Swartfigger told him, no, this is how I do stairs. This is how they are. They're good to go. That's what Mr. Cleveland relied on.
Mr. Cleveland relied on the person who he hired to do work at his property. He relied on his representation.
I will give this to your client. Those stairs, for somebody who's not familiar, they looked pretty non-temporary. They looked like they were legitimately built and permanently built.
Yes, Your Honor, and that's evidenced by the way that he used the stairs. He watched Mr. Swartfigure use the stairs multiple times with his son. My client used the stairs with his family. And then in this instance, the unfortunate accident, it was my client's friend. My client was effectively, he asked him to assist him at the house, but he was showing him the house and the work that had been completed. He understood the stairs to be safe. And then unfortunately, this is the accident that happened. They looked complete, but
we understand. Thank you
Yes.
very much.
Yep. Thank you. If there are no further questions, I'll rest my papers. Thank you, Your Honors.
Thank you. Mr. Gascon?
You're muted, sir.
Yes, you're muted. There you go.
Good afternoon, Your Honors. James Gaskin on behalf of defendant Jason Swartfigure. I would start out by saying that the measure of review by the trial court is that the court is compelled to view when there's a motion for summary judgment, the court is compelled to view the facts in the light most favorable to the non-moving party, and that is my client. And my client testified that Mr. Cleveland, the owner of the property, referred to himself as the construction manager, and he in fact did manage the overall construction of the project. He did not have a general contractor, and he hired my client as a subcontractor. Mr. Cleveland directed my client to build a temporary landing for the staircase to be relocated once Mr. Cleveland ultimately determined how he wanted the staircases to work. Mr. Swartfigure, my client, repeatedly said that Cleveland that the installation of the staircase was temporary, and that Mr. Cleveland had assured Mr. Swartfigure that he was going to finish the stairs installation by enclosing it underneath with either walls or additional bracing himself. So the homeowner assumed the responsibility of further securing the staircase later on down the road. Now, my client also said that when he left the property, he said to Mr. Cleveland, before he left the job site, he asked Mr. Cleveland, it gave him several warnings regarding the temporary installation of the stairs, including that there should be additional fasteners to secure the same. Mr. Cleveland assured Mr. Swartfigure he was going to finish the stair installation and properly support the stairs that weekend, which he did not do. So the homeowner was fully aware of the way that it was installed. He even questioned the installation. He told my client only put in a minimal amount of screws because he was gonna further secure it down the road. He was gonna further determine whether or not he was gonna bend the staircase and reconstruct it himself further down the road. He was fully aware of its installation, the way it worked. Now, Judge McCluskey was keen to point out the following fact. In his decision, he says, no allegation is made by Mr. Cleveland that he had no knowledge of how the staircase was affixed to the first floor. Indeed, his complaint to Swartfigure was only that he was concerned about how it looked aesthetically. During the course of discovery, Mr. Cleveland acknowledged that Mr. Swartfigure repeatedly said that the installation of the staircase was temporary and that he had assured Swartfigure that he was going to finish the stair installation himself by enclosing it with walls. So this homeowner also served as the construction manager, had a dual obligation to make sure that the stairs were installed properly. He was fully aware of how the stairs were installed, and he had a duty to, and he had constructive knowledge, if not actual knowledge, and he had a duty to warn his friend that these were temporarily installed and not fully installed at the time.
I think we understand the argument. Thank you so much.
Thank you, Your Honors.
Case number 310 is Oni versus Creative Developments of Oswego. Case number 310. Mr. Lyon is with us, waiting for Mr. Welch. Mr. Welch is here as well, and we may proceed. Mr. Welch, good afternoon to you.
Thomas Welch, excuse me, for the appellant, Mr. Oni. Pike made a motion for summary judgment that was denied by the trial court. The court dismissed the case on its own accord, finding that the activity that my client, Mr. Oni, was involved in, which was the pulling of nails from a 2x4, was not an activity that would endanger the eyes pursuant to the New York Code of Rules of Threat. We disagree with that assessment. We have defendant witnesses that say that that testified that the activity of removing nails from a board would require the use of eye protection. It wasn't provided to their own. I think the court was
is it possible, in your view, that whether pulling nails towards you rather than hammering them in, as was the case in Herman, pulling nails toward you, that there's an issue of fact, because we're relying on that last phrase of the regulation, because there's no cutting, there was no chipping, no grinding. You're relying on that other activity that may endanger the eyes. Is it possible that whether that last clause applies turns on foreseeability, which would then be a matter for the jury? Is pulling nails, or can we say as a matter of law, pulling nails may endanger the eye? We know it did here, but other cases have read a foreseeability element into this regulation.
Well, I would say that that activity of pulling nails, as you say, totally different than driving nails, because you're pulling the nails towards you, that it would be foreseeable that somebody could
As a matter of law.
Yeah. Or even if not as a matter of law, there's, it would be a question for the jury as to whether
This particular nail in this case hit the floor first, as I understand the record, then it bounced back or it hit another object. It wasn't just pulled directly into the plaintiff's eye.
Yeah.
So it was a ricocheting nail?
Sounds like, I think so.
Right, and that's what we had in Herman, though, a ricocheting nail.
Right, but the activity that our client was involved in was different than nailing the nail. He was actually pulling the nail towards him. So that's a different activity than what was in the.
In your view, it's more likely to have a ricocheted nail hit you in the face if you're pulling it towards you than if you're driving away from you.
Or hit you directly in the with that.
So it does seem like kind of a freak accident. You're pulling a nail out, it hits some other object and then hit the guy in the eye. It's that particular scenario isn't foreseeable, I don't think, but maybe getting injured in the eye when engaging in that activity would be foreseeable, or maybe send it to the jury and they determine what's foreseeable. Foreseeability is usually an issue of fact for trial. But either way, you want us to reverse the judgment that was granted to the defendant.
Right. It wasn't proper to just dismiss the case outright. If he didn't want to grant the motion for summary judgment, fine. And we will go to trial on the issue.
But Mr. Welsh, getting back to some of the questions asked here, which direction the nail was going, that is pulling it towards you or pounding it away from you, would have no bearing as to the language you rely upon in the regulation, correct? There it says, while engaged in any other operation which may endanger the eyes. That language of the regulation would cover either, correct?
Correct.
So there's no way to distinguish Herman on that basis because the regulation would cover either. We'd be acting inconsistently with Herman if we said that that language included this conduct but didn't include that conduct, because it doesn't limit it to which direction, does it?
No, it does not. But I don't believe Herman the Herman court even mentioned that part of the reg that says any other operation which endanger the eyes. They just went through the the listed activity.
Do you read Herman as essentially saying that the last phrase that we're talking about, while engaged in any other operation, should be read together with the rest of the regulations with respect to the other types of operations and functions that are described in the regulation? Do you read Herman that way?
Well, I read Herman as saying that there's specific activities which are listed in that section that are covered. And then there's the catch-all phrase that says any other activity. And wasn't specific. So it's covering all these other activities that weren't enlisted.
So are you saying Herman was just an oops? That is, we missed that phrase in the regulation, which I don't know if we'd want to concede that. That is because if we focus on that language regulation, wouldn't you have to argue that Herman is encompassed by it also, given its breadth?
Yeah. I'm looking at this. I don't believe they addressed that phrase.
Yeah, they ignored it in the decision, I believe. Herman didn't mention it in the decision, as I recall.
But the regulation was the same then as it is now, to my understanding. It's not been changed in terms of its wording. So we either committed an oops in Herman, because I think your argument is, well, if the Herman court had looked at this broad language in the regulation, it would have to go the other way, correct?
Right, but also there's, I'm going back to the argument of the activities were different as well. I mean, they relied on the fact, the trial court and Herman relied on the fact that he was pounding a nail, and it wasn't foreseeable to see that nail come flying up. Here, he was pulling the nail, and I think
like Kuros is a case. Kuros, 2015 case from this department was a pneumatic gun, nail gun, and we distinguished Herman on that ground. That seems to be what you're trying to distinguish Herman rather than have us disavow it. Fair to say? I'm sorry, just you had something.
Okay. Now, Mr. Walsh, just to kind of complete the thought for me anyways, I found a number of cases that indicate that whether one of these regulations or that the interpretation of one of these regulations and its application to the facts is a question of law for the court. Do you agree with that?
Okay. Yeah.
Okay. So you're indicating that not so much the foreseeability is a question of fact that would go back, but we should find as a matter of law in your favor that in fact interpreting this regulation covers this type of conduct. It applies to this type of conduct. And yet suppose you would even push it so far as to say it was violated, and we should grant you summary judgment finding a violation of the regulation. Is that what you're arguing?
Well, that's our argument, and if it's not found, if summary judgment isn't granted, I still think we could argue there's a question of fact as to whether that.
Right. In your brief, you argue at the very least an issue of fact with regard to foreseeability exists. So you should at least get the trial, and are you abandoning that now? Are you saying you have to win or lose as a matter of law? Or are you saying there's another option, is that it's, as you say in your brief, issue of fact?
I'm saying there's another option.
Yeah. Thank you very much.
Thank you.
Mr. Lyon.
Good afternoon, Your Honors. May it please the court, Brendan Lyon, appearing for the respondent. As you guys mentioned, I really think you hit the nail with the Herman case. And
no pun intended.
In my own experience, I do believe actually manually hammering a nail is more dangerous than pulling a nail backwards. And on top of that, not only did the nail, when it was going backwards, not go directly into the appellant's eye, but it bounced off a piece of wood and then struck his eye. And I know in Herman, the court noted that it was a freak accident, and therefore they cannot find any liability under the regulation. And then when it comes to foreseeability, I know there's other cases in the First Department. One was mentioned in our brief, Capella versus Telehouse International Corp. That case was somewhat similar. The plaintiff was driving a masonry nail, so a nail that's a little bit larger. not only into plywood, but then also into sheetrock. And there's testimony from the plaintiff that a ricocheting nail was not an uncommon occurrence. And ultimately, the first department said it was a question of fact. However, here, the plaintiff testified that just weeks prior, he removed 200 to 300 nails from scrap wood at a volunteer fire department. And then he also testified that during that prior work, he never used safety glasses or even his own prescription glasses. At all times prior, he never used prescription glasses or his safety glasses when it came to doing similar work. And then he also testified that he did not believe there's a risk that nails could go flying when it performed that kind of work, the work that plaintiff was engaged in. And so I just think as a foreseeability matter, I don't think a jury would find that it was foreseeable. In fact, based on plaintiff's testimony, I think a jury would find it was unforeseeable, and then therefore the trial court properly dismissed this case. And then just my last point here is that I know a lot of the cases that were cited either involved a power tool. So for example, the Fourth Department of Quiros, there was a nail gun. Multiple cases involved drills. Power tools and drills, like the Fourth Department noted in Quiros, those are far more inherently risky and dangerous than a manual hammer. So,
Mr. Lyon, in your research, did you happen to come across the definition of suitable? That is in 23-1.8, the regulation that we're so focused on in this case. It talks about at the very beginning, approved eye protection suitable for the hazard involved. And then looking previously at 23-1.4A, in that same section, definitions, it defines suitable as meaning, and it's not just suitable, it's other words too, meaning such materials, devices, structures, methods, and procedures shall be of such kind and quality as a reasonable and prudent man experienced in construction, demolition, and excavation operations would require in order to provide safe working conditions. So when we interpret this regulation, don't we have to look at those definitions? And isn't there a question of fact about suitability here?
Not necessarily, I don't believe so, because well, what would be suitable, if you're going to say there's a question of fact with foreseeability, is that it would be suitable that the plaintiff either would have been wearing his own prescription glasses to protect his eyes, or he would have at least had safety glasses that while he was not directly instructed to wear them, they were on the job site. And back to foreseeability, and really if there's a question of fact, I believe how he testified that he removed hundreds of nails just weeks prior and never used any type of safety glasses or his own prescription glasses. There's not really a question of fact whether there was, I guess, a suitable protection available or suitable protection.
Mr. Lyon, in fairness to you, I do have to acknowledge, plaintiff hasn't argued the point I just raised, but it's a thought that occurs to me in trying to figure out how we interpret this regulation. Because it's obviously, our court, I think, at the moment seems to interpret it differently than other departments, I think. But then my question is, do you agree that Judge Gilbert at Supreme Court first and foremost found that this question was a matter of law, it had to decide as a matter of law? And I think it's cited to Besderick, one of those Court of Appeals cases. But am I correct that Supreme Court concluded that this was a question of law for it to decide?
Yeah, I know Justice Gilbert actually quoted that I believe it's a Besderick case from the Court of Appeals, that the applicability of regulation here, so 1.23, 1.8a, that's a question for the court. And based on his interpretation of the law, he didn't.
So those foreseeability cases are wrong? Because you were just talking about before, plaintiff didn't raise an issue of fact on foreseeability, but if it's a matter of law, that doesn't matter. We don't get to the jury on foreseeability.
Well, correct. I think what happens is that if the judge finds that there is, as a matter of law, applicability, for example, in Quiros, the judge found that actually using a nail gun, that is encompassed in the regulation. However, the judge still said that it's a matter of fact whether the defendant actually violated the regulation.
How about this? Last question for me, at least. The plaintiff wants us to grant judgment to him as a matter of law. Grant the plaintiff's motion for summary judgment 241-6 based on the eye protection regulation. There appears to be an issue of fact as to the nature of the plaintiff's work at this site. His boss says his job there, he was just clearing debris, clearing things out. He was not instructed to be pulling nails out of anything. They didn't give him the hammer. He says, the plaintiff says, yes, that was part of my duties. Assuming that the regulation applies, is there an issue of fact for trial based on what he was actually doing? Does the employer have to provide goggles for somebody who's merely cleaning debris? And the chance that employee may freelance and start doing some other activity?
I would tend to say no. And there's a First Department case, I believe it's called the Roquet. It's cited in our brief where there's actually an ongoing demolition site, and the plaintiff was engaged in an activity similar to this. He was demolishing a sidewalk bridge, and there the court said there's a question of fact. And they relied on not only the activity plaintiff was engaged in, but also that it was ongoing demolition. I think here the testimony is clear that there was no ongoing demolition. So I don't think there could be a question of fact. For example, with a demolition site, there is a possibility that there may become airborne debris, where here plaintiff was simply instructed, at least according to Mr. Beach, to just remove debris and computers from the second floor of the building.
Mr. Lyon, this is probably my last question as well, but following up on what the justice presiding was asking about the belief the plaintiff is looking for summary judgment on liability in terms of a violation of regulation. But I thought our department says that any such violation does not establish negligence as a matter of law, but is merely some evidence to be considered on the question of defendant's negligence. And I'm actually quoting from Courthouse, which quotes the Physicus. So in our department, that's merely some evidence of negligence and doesn't get you all the way to liability. Do I have that right?
Correct. Yes, that's how I interpret it as well.
And you argued that, at least in your motion papers below, as I understand it, right?
Yes, correct. Yeah, we actually, I believe,
Kuros,
said that as well.
Kuros was 2015, before Rodriguez, Court of Appeals decision. I question whether Kuros was based on the old theory in some quarters that comparative fault was part of liability. That may be a remnant of that. I don't know. There's a lot of issues here. That's one of them we'll have to track down. But we appreciate your time today.
Thank you.
Case number 311, last one on the docket is Indini Montez and Rosa Montez versus City of Rochester.
Good afternoon. Michael Steinberg for the plaintiffs in this case. There are two issues here, and I want to start with the issue of duty. The city has taken a rather extraordinary position, which is that, and I'll quote here, the only duty that could possibly apply in this case is the duty that Supreme Court articulated to design and maintain roadways in a reasonably safe condition. That's a very well-known duty. It doesn't apply here. It applies to the need to make roads reasonably safe for travelers. It's non-delegable.
On the roads.
What?
For people, that duty extends to travelers, pedestrians, and the like.
Exactly.
You're not relying on that.
We have never relied on that. We have never changed our theory.
So this is just whether there's a duty. Otherwise,
there is.
Under ordinary negligence principles, foreseeability, Paul's graph. The scope of the duty, and if you want to take it from there, we can.
The duty is very clear because the city was aware that now and then people go through these T intersections and come in contact with houses. And they've tried to do things about it.
Or pedestrians walking on sidewalks.
And they've tried to do things about it. What they did was not probably the right thing to do, but it clearly shows that they recognize the problem. Having recognized the problem, they have to act in a reasonable way to keep its inhabitants safe from cars running into their houses.
Is that a proprietary function of government or a governmental function?
It is a proprietary function. It is not something that has to do with the design of roads, which is for the use of the drivers on the road.
Because if it's governmental, then you have a problem with a special duty.
The city has never said that it was a governmental duty. In fact, they say that it's a proprietary duty.
I'm just saying, if you need it to be proprietary.
We do need it to be proprietary, yes.
The other duty that you're not relying on is proprietary, they admit that.
Yes.
They don't necessarily admit that this other duty to homeowners or pedestrians is proprietary.
I don't see, Your Honor, that there is any meaningful distinction between those two kinds of duties.
Okay.
This is something that it's a straightforward negligence case. They have created a situation which makes certain houses, puts certain houses at risk and their inhabitants at risk. And it's not a governmental function. You can't decide whether or not it's appropriate to do that. It's a proprietary function in the sense that in the same way it's a proprietary function when you build roads and have people drive on them.
All right. So if you're right on that, then we just have foreseeability defines the scope of the duty. Is it foreseeable at a T intersection under these circumstances? You would argue at the least it's a question of fact for trial.
Your Honor, it is foreseen. The city kept putting up these guide rails. There's no reason to have those guide rails except to try to keep cars from going onto people's property. And that's pretty obvious in the layout of the guide rail here. The guide rail is not facing the Montez's house because the Montez's house looks at traffic going away. It's the next door house.
And they put one at 271 coming the other way.
Right, because that's where the traffic is headed. And so the city knew this was a problem. We have that letter from the late Mayor Ryan, similar kind of problem. Everybody really knows that this is not what they're supposed to do, but it's what they do. What that does show is they're aware of the problem. And then, since there is a duty, and since the duty is to act reasonably so as to protect its citizens from this foreseeable danger, the city failed to do that, and its failure was one cause of this accident. Obviously, Mr. Glenn's driving is another.
Right, so the failure here was the failure to put a warning sign, neon flashing light, what have you. The guide rails are for drivers, not it's not a warning signal in your view.
That's true, and in fact, the guide rails are actually guide rails. Right. They're meant to keep people from contacting it and going off the road. They're not meant to absorb a head-on collision.
Different from a guardrail.
Yes. Didn't need to be a neon sign. Mr. Surth, our expert, said double arrow, black double arrow on yellow background is acceptable. And we certainly have a question of fact as to that playing a causal role in the accident. Judge Vazana said that it's purely speculative that Mr. Quinn would have turned had he known about the T intersection. But in fact, he was turning. The city's own expert says he was turning. The city's own expert says he was braking. And in fact, if he had not turned, he would have hit the guide rail.
Right. They seem to make much of the fact that he blew through other stop signs. But that going through those stop signs, if there's no cars, didn't endanger himself. Mm-hmm. Like somebody I could see going through a red light stop sign would look at it differently going through a house.
Yes.
You might say, I don't want to, I'll go through a stop sign if nobody's there, but I'm not going to go through a house.
And he clearly was trying to avoid the danger. I mean, there's certainly at the very least there's a question of fact that he was trying to avoid the danger.
Why you say a warning sign in front of the house, like isn't the house itself a warning sign? Like when you drive in and you see a house, isn't that a good enough warning you should turn before you run into the house?
It was night and people were asleep. I doubt there are very many lights on. And there's a light to the side of the house. That's a question of fact.
So if this happened during the day, tougher case for you.
Yes, there would probably be some complications had it happened during the day, but it didn't happen during the day. And Mr. Surth went to the scene where there were similar lighting conditions and found, there is testimony from him or an affidavit from him that says, no, you really can't see until you're quite close that the road comes to an end. And I think that's enough to create a question of fact here. I think it needs to go to a jury. There is, there's no doubt that Mr. Quinn was operating his vehicle in a dangerous way, but this is a dirty Aryan case. The risk that was posed by the negligent driving of Mr. Quinn, Glenn, is exactly the risk that the city was trying to remedy with putting in the guide rail. And so you can't say that his negligence cuts off their liability. So we have a clear duty. We have certainly a question of fact about the reasonableness of the acts that the city did to deal with this foreseen danger. We have definitely a question of fact as to whether or not earlier notice, more visible notice that the road was coming to an end, would have avoided this accident altogether. Because the driver really did try to avoid it. I said, if he hadn't tried to avoid it, he would have hit the guide rail. He wouldn't have hit the Montes' house. And so there is a definite case here that goes to the court, goes to the jury. This is not a summary judgment case. And Judge Mazzano was wrong in saying there was no duty, and he was wrong in saying it was merely speculative to say that the absence of notice had nothing to do with it.
Counsel, looking at the Lopez case that the city defendants rely on, they talk about how the duty is limited only to the traveling public. And this is, again, the duty to maintain roadways. And normally putting up a road sign, which is what you're claiming the negligence was here, that would normally be part of the responsibility. So essentially, it seems to me that you're arguing that a city's responsibility to put up a warning sign, there's actually two separate duties to do that. Both are proprietary. One is a duty to the motorist, and then there's a second duty to adjacent homeowners, correct?
I think that's a good way of looking at it.
Has any court ever found that?
I don't think any court's ever been presented with this case. I've looked, and it's been very difficult. Lopez is not on all fours at all. It has to do with a worker who was injured by traffic that wasn't aware of the conditions of the roadway, the construction area. And
the worker in Lopez was injured by the negligence of his employer.
Yes, it was his employer's failure to.
The Court of Appeals in Lopez, as I read it, they were more concerned is not our responsibility. We delegated that to the contractor. And that played a significant role there because somebody was at fault. Now, unfortunately for the plaintiff, workers' comp barred that.
Yeah. But
there was at least somebody responsible there for the safety. Here, you would argue, if not the city, nobody.
Right, because in Lopez, Lopez had the construction signage led to an accident that injured somebody using the road. The county would have been liable because it's the non-delegable duty to those who use the road. Mr. Lopez was not a person using the road, and the county was not negligent. And it's not vicariously liable for the negligence of the contractor as to the protection of the contractor's employees. Whereas it is vicariously liable for the negligence of the contractor insofar as it made the roadway less safe for drivers. That's the difference. Here, yes, there is the specialized, highly restrictive form of liability that municipalities owe to those using the roads. That doesn't cut out their ordinary common law negligence under Palsgraf principles.
Right now, I'm just trying to envision what this does to the municipalities throughout the fourth department. What are those highway departments going to need to do if we find this duty to all of these adjacent landowners to all the roadways? Are they going to have to go out and survey every single turn of a road, every single, end of, it's not just end of T intersections, it would be anything where it would be foreseeable under Paul's Graph principles, where a car might go off the road and damage property. I suppose it would be property damage in addition to personal injuries. But it seems like we'd be putting an awfully large burden on all the municipalities, all the cities, all the towns, all the villages are gonna have to go out and examine all the roadways and all the adjacent property owners' situations. If there's somebody has a trailer too close to the road, we better put up a sign. If somebody builds a shed too close to the road, well, we better put up a sign. We have to protect the shed. It seems it's a lot of work for municipalities.
It would be a lot of work for municipalities, Your Honor, if in those cases there were frequent instances of similar accidents. Here we do have a history of accidents.
History of accidents in this case?
Well, in this very area of the city, there are numerous.
Not at this T, though. There's no accidents at this T ever.
But they put one there for this very reason.
They assumed the duty.
They did assume a duty. They certainly acknowledged the duty. And they did not respond appropriately in the light of their knowledge.
You're not asking for something, I mean, you're asking for one of those T signs at the end of these T intersections.
Yes, something that's visible at night.
Not a big deal.
No.
Not reconstructing or redesigning roadways, just a T sign.
That's right. In a configuration of roadways in a part of the city where cars were occasionally going into houses.
There is some responsibility in your mind, there is some responsibility on the part of a town or a county or anyone else to make sure that cars don't leave the roadway and run into places where people are sleeping.
Yeah, and I drive around here in the countryside, you'll see similar signs when roads curve around houses.
There's a lot of signage.
Yeah, there are a lot of signs. They'll be illuminated, or not illuminated, but black and yellow turn signs, the chevrons that lead you away.
So, not to belabor the point, but the flip side is, if we were to say there's no duty here, that would mean there's no duty on a country road to mark a sweeping curve where an unfamiliar motorist wouldn't know at night or during a snowstorm that beware, there's a turn coming ahead. And you could leave the roadway.
And the interesting thing is, if that's the case, and you don't have the signs, and so there's no reasonable notice to the driver who goes through there and goes into the house would recover against the municipality because the roadway was not reasonably safe. But the people in the house would have no recovery at all.
Right, that's the twist here, is that under Justice Del Conte's questioning, I think the city would say, no, the municipality does have a duty to put up warning signs on behalf of the drivers because that's where the duty's owed. There's no duty to people in the houses beyond. But as you say, it leads to a very odd result.
Yes.
A driver who's negligent, intoxicated, speeding, goes into the house, they can sue the city. The person who's sleeping and gets run over by the car can't.
Yes, if in fact the city had not made it reasonably safe.
Right.
This is a fairly narrow issue because this is an issue in which the city had noticed and tried to respond to this danger. And the other instances you suggest are in the character, in a way, of freak accidents. They're just not reasonably foreseeable. Whereas this one was clearly foreseeable because the city was trying to do something about it. And so we are very, very confident that it is worthwhile being the court that says, yes, there is a duty here. Maybe under the facts, it's for a jury to decide if liability is proper. But to say that the city has no duty to anybody outside of its roadways because of the configuration of the roadways seems very, very extreme. And we ask you to reverse and give us our day in court.
Thank you.
May it please the court. Good afternoon. My name is Carla Williams-Pauley, and I am representing the respondent, City of Rochester, in this matter. The driver in this case was swerving on the road. Instead of stopping for a police officer, he accelerated. He blew through a stop sign. He blew through another stop sign going 94 miles per hour. He swerved at the T intersection and hit the appellant's home. If this had not happened, if he had taken any modicum of care, then we would not be here today.
That sounds like a proximate cause argument, and it would seem that we would need to first find a duty running to the plaintiffs. Is that something that you're willing to stipulate to under these facts, that there is a duty in this case running to the plaintiffs and that we should go right to the proximate cause question?
No, not necessarily. The city's position is that whether you apply the standard that the lower court held or whether you apply the standard that the appellants propose is not going to make any difference here. The appellants know and have conceded that the duty that the lower court applied doesn't run to them because the appellants were not users of the roadway at the time of the accident. So instead, they base their entire argument about foreseeability and try to create a duty where there was not one, and where they admit they have not seen one in any sort of case law, which doesn't seem to make sense in all of New York's jurisprudence that this would not have come up before.
What would have been, sorry, what would have been the point of putting in the guide rails if there wasn't a duty, I mean, here?
We don't know exactly why the guide rails are there. What we do know and what is in the record is that in 1989 to 1990, there was a reconstruction plan set, and in that reconstruction plan, the city at that time had planned for a guardrail. So presumably they...
Guide rail or guardrail?
I'm sorry, guide rail.
Okay.
So at that time, they had planned for a guide rail. We don't know exactly what happened after that. The only other thing we know is that the city's policy in 1993 was not to put guide rails except for the purpose of a guide rail, which is to guide parallel traffic. So we don't know exactly when it was put there. We don't know exactly why it was put there. It is speculative for the appellants to say that it was put there specifically to guard oncoming traffic.
And maybe that's the distinction. Getting back to Justice Delcani's question before, with opposing counsel previously, this idea about, well, the municipalities aren't going to be protecting, a country road curving and all of that. There's still a duty owed to the motorists.
Absolutely.
And there's certainly the foreseeability that a motorist might go off the road, and that can always cause injury because you don't know what's going to happen once the vehicle leaves the roadway. So municipalities have that now, and that's in place right now. It seems to me that what the plaintiff's seeking that we extend here is that the duty also protect private property adjacent to the road, that now becomes within sort of the ambit of the responsibility. And so that means that maybe a guide rail, which is designed to protect a vehicle, keeping them straight, becomes a guardrail, where you now protect the house that's too close to the road, and that the municipalities have that additional burden. I haven't seen that in the law, but would that necessarily be a difficult extension for the municipalities?
Well, I think for the municipality, it wouldn't have made sense for them to put a guide rail there for the purpose of being a guardrail, unless that was the standard back in 1989 and 1990, which maybe it was. And since there were no prior accidents and no prior complaints about this particular T intersection, and specifically the location at 284 Ferncliff, the city would not be on notice of having to go back and look at this intersection and rethink the design and make a decision as to whether there should be additional safety measures such as a sign.
Do you think it's a governmental or proprietary function to protect homeowners from errant vehicles?
What I do know is that the duty for making roadways safe is a proprietary function. We know that from the case law.
Yeah.
Since this duty to protect homeowners specifically has not actually come up in the case law, I can't say for sure what it would be in that case, because this has not come up. And the appellants are asking for this court to extend the duty where it has not extended to before.
Seems like a similar duty.
It is.
right?
It is. That's the thing. Is that
so if one's proprietary, you're saying why would the other one not be?
It is a very similar duty because ultimately what the appellants are asking for is for us to put up a warning sign, to put up a two-way directional sign. And that's what they think would have made the entire difference in this case. A two-way sign is for the benefit of the users of the roadway. So this must necessarily implicate the duty to make roadways reasonably safe, if a duty were to apply at all to these appellants.
So if there is just this general negligence duty to the Montez, do you think it's foreseeable that a car would go through over the lawn and the curb into their house?
No, absolutely not. In this area, it's a 30-mile-per-hour speed limit, which is the speed limit for the entire city at that time. There was a stop sign at Lux and Ferncliff, which is the T intersection. There's a stop sign at Lux and Claremont, which is only 2 houses away, which the driver here blew through. Again, there were no prior accidents. There were no prior complaints about this T intersection. And the appellants were unable to point to any statute, any law, any regulation that would actually mandate a two-way directional sign at this intersection.
Right, but just talking about foreseeability, you're saying no, he's saying it was foreseen because they had the guide right there in front of the house next door. So it was actually foreseen, not could have been foreseen. Or at least an issue of fact. I mean, he's not saying, grant me judgment and let's talk damages. He's saying, let me try to get to the trial.
Counselor, I'm really stuck on the duty.
No, please.
I mean, there's got to be a reason why the Court of Appeals has never recognized a duty in this context. I mean, when they recognize the duty, we know they go through a policy analysis, you can look for all the different factors, they do that. They've never done that here. So for us to recognize a duty that is of general duty of negligence, the duty of negligence is relational, right? What obligation do I take on by participating in human conduct with my fellow man or woman in reasonable conduct? So if we recognize a duty here, why don't we have landowners have a duty to have trees between or fences between? I mean, it seems to me just to say, oh, there's some general duty. We know that foreseeability does not create the duty. Foreseeability defines the scope of the duty. So do you know of any case that finds a duty of any defendant in this context to a landowner to put something up to protect from an errant driver?
No, I do not. And regarding the general duty of negligence, the city generally does not have a general duty of negligence. So usually there would have to be a special duty for the issue of negligence in order for that duty to apply.
In your brief, you cited Ferreira, and in the Ferreira case, the Court of Appeals indicated that the municipal entity is engaged in a proprietary function when, well, let me flip the coin the other side, exercising a governmental function when it's undertaking functions or services that are not typically provided by private actors.
Mm-hmm.
It seems to me, I don't know of any private actors that goes out and looks to see if private property is being protected under certain circumstances. That sounds to me like a governmental function, which then brings us back into the special duty, which I think is what you claimed right from the beginning.
Right, exactly. Thank you. That was more eloquent than I was.
Anything further?
No, Your Honor. Thank you.
Thank you so much.